Thank you so much. Well, good morning, everybody. I now declare open this public hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the provision of the Criminal Code Amendment Deepfake Sexual Material Bill 2024. I acknowledge the traditional custodians of the land on which we meet and pay my respects to elders past and present. I'd also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are participating in today's public hearing. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live in Parliament House via the web. For people participating remotely, I'm the chair of the committee, Senator Anita Green, and joining me today is Deputy Chair Senator Paul Scarr. Senator Larissa Waters is also joining us at some stage this morning via video conference. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolution, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that an answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly into the microphones to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. I now welcome, via video conference, our first panel of witnesses. I welcome Ms. Noelle Martin and representatives from the Queensland Sexual Assault Network, the National Association of Services Against Sexual Violence, and the Rape and Sexual Assault Research and Advocacy Centre. Thank you for taking the time to meet with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. But for the Hansard record, can I ask you to each please state your full name, the capacity in which you appear today. And we'll start with you, Ms Martin, if you want, and then we'll go through our organisations that are with us today. You might still be on mute, Ms Martin.
Hi, my name is Noelle Martin and I appear in my personal capacity.
Thank you, Ms Martin. Ms Lynch.
Oh, hello, it's Angela Lynch. I'm the Executive Officer of the Queensland Sexual Assault Network and I appear representing the Queensland Sexual Assault Network today.
Thank you very much. Ms Lambert. We have an issue with your microphone, Ms Lambert, even though you don't appear to be on mute. I'll just go to Dr Bergen while we fix your audio up.
Good morning. My name is Dr Rachel Bergen. I appear on behalf of Rape and Sexual Assault Research and Advocacy today.
Thanks very much. And we'll give that one more go, Ms Lambert, otherwise we'll...
Hopefully that's working now.
Yes.
Sorry about that.
That's okay.
My name is Nicole Lambert and I appear today as the Chair of the National Association of Services Against Sexual Violence.
Thank you very much, and thank you all of you for appearing today, and thank you for your really considered submissions to this inquiry. They have really assisted the committee in preparing for the hearing. But before we go to questions, which I'm sure there are many, does anyone want to make an opening statement today? Ms Martin, we can start with you and then we'll go through our organisations.
Sure, thank you so much. Good morning. I want to thank the committee for the invitation to appear in this public hearing. I planned to attend in person, but due to flight delays, I had to cancel my flights at the last minute. By way of introduction, my name is Noelle Martin. I'm a global activist, lawyer and researcher at the University of Western Australia Law School. I draw on over a decade of lived experience as a survivor and a continuous target of image-based abuse and deepfake abuse. As I briefly discussed in my private submission, overall, I consider these proposed laws a step in the right direction, despite the fact that deepfake abuse has become a mainstream, prolific, global and borderless issue, and there is only so much that any country can do to tackle this issue alone. However, to the extent that the Australian legal system can act in Australia and for Australians, I'm not necessarily convinced that this bill will have as much practical utility as one would hope to stem the tide of this abuse meaningfully or systemically. I have two main concerns about the practical utility of this bill. The first relates to the impracticality of one of the aggravated offences. The second relates to the limited and narrow scope of these proposed laws. First, on the impracticality of these proposed laws. One of the proposed aggravated offences relates to the transmission of sexual material without consent only after certain civil penalty orders have been made. This proposed offence is impractical as its operation is dependent on whether the eSafety Commissioner has sought civil penalty orders for contraventions of the Online Safety Act. As is clear from the online safety regulator's track record, civil penalty orders are rarely, if ever, sought by the eSafety Commissioner. Unless this committee seeks to revise this offence, it will have little to no work to do. Second, on the limited and narrow scope of the proposed laws, there are many powerful actors and different types of conduct involved in the deepfake abuse pipeline, beyond individuals involved in the creation and/or transmission of deepfake abuse that this bill seeks to address. Creation and/or transmission is just one small part of this evolving industry. We are dealing with search engines such as Google, who facilitate and profit from this abuse by enabling the access and discoverability of deepfake sites, to payment processors such as Visa and MasterCard, who facilitate the monetary exchange of this material, from individuals who solicit the creation of deepfake abuse or access material, to website owners and operators of massive deepfake hubs who host large amounts of this material. I would urge this committee to strongly consider and report on exactly who the actors are in the deepfake pipeline, what types of conduct takes place, and what criminal liability certain conduct ought to attract. In considering how to navigate this, the committee can consider how existing criminal offences that relate to abhorrent violent material are dealt with as a start, which prescribe criminal penalties for body corporates who fail to remove abhorrent violent material. These are 2 brief points for now. I'm happy to discuss this broader issue further to the best of my ability.
Thank you so much, Ms Martin, and we will come back to you. We've got a lot of questions for you, particularly about your lived experience, but on some of those issues that you just raised. Ms Lynch, we'll go to you next if you've got an opening statement. Thank you.
Thank you, Senator. QSAN, or the Queensland Sexual Assault Network, is the peak body for sexual violence, specialist sexual violence prevention and support organisations in Queensland. We represent 23 specialist organisations. We agree with the policy intention behind this legislation, but really suggest the following changes. We agree with the Associate Professor Michael Flood that the proposed amendments should include a standalone offence of creating a sexually explicit and or altered deepfake material of a person without consent. We'd also seek that there is specifically recognised threats to publish should also be part of the criminal offence as well. At the moment, they are not. We are also concerned that the offence provision may not cover animation or avatars or alter egos that are created in the like or to resemble people, and that hasn't been. It's tried to be covered off, but because of the reference to person in subsection 1 of that provision, it opens the door for defence to argue that the creation was not a person. So that needs to be considered and looked at. We also agree with the Federal Prosecution Service that there are issues in the proposed legislation adequately covering the situation where a person's face, for example, is uploaded using material from an existing publicly available porn site. And they say in their submission that there's real concerns that the current legislation doesn't cover off and give protection in those circumstances. We also agree with Relationships Australia to change the name of the Act to reflect that it's broader than deepfake issues. We also agree with NSASIV and are a member of NSASIV that the requirement for establishing an aggravated offence is too high, and obviously Ms Martin has just spoken to that issue as well. We do question whether there should be the availability of court injunctions and court enforcement provisions in the legislation as well, if it gets that far to a court hearing, and just ask for that consideration in those circumstances. We'd also like consideration of the funding impacts of these new crimes. These crimes can have a number of victims and can impact a number of victim survivors, and ultimately those people will be seeking assistance and support through the specialist sexual violence services, who at the moment face already lengthy wait lists for people to get through. That's the end. Thank you.
Thank you very much, Ms Lynch. Dr Bergen.
Thank you. I appear today as in my capacity of CEO as Rasara. I will sort of skim through my comments because I think my colleagues have covered lots of it substantively, and I want to particularly thank Noelle for her words before. In preparing for today, we had the opportunity to consult with our colleagues, including Angela Lynch and Professor Asher Flynn, who I understand is appearing this afternoon. And so we endorsed the position of Professor Flynn in her capacity as a leading expert in this space. We'll also note that, in the context of widespread and easy access to AI, or as Noelle said, such deepfake material is becoming prolific. It has a significant impact on victims and on society. Victims experience significant psychological trauma, fear for their physical safety, and are often forced away from the online world. In the digital age, that means that they have fractured access to their social bonds, to the economy, to education, and to work. And for these reasons, Rasara supports the bill. However, we agree with our colleagues who've spoken already today that the bill simply does not go far enough. At present, it does not create an offence for the creation of deepfake explicit material without consent. An offence is only committed if the images are distributed, and then it becomes an aggravated offence. But creation alone carries no offence. The creation of those images, whether or not they are distributed, is a significant harm. And commonly threats to circulate intimate images, including deepfakes, is a tactic used by abusers to instill fear and exert control and power over another person. Those threats need not be explicitly made to be, to achieve their ends of controlling. We would suggest, though, that an offence of threats should also be created under this, threats to distribute should also be created under this bill. So we do recommend that the bill goes further to ensure that the creation alone is captured. Briefly, although we do support an aggravated offence for the transmission of sexual material without consent after civil orders are made, we don't agree that 3 previously ignored penalty orders should be required to reach the threshold for aggravation. Ignoring 1 civil penalty order should surely be considered an aggravating offence. And I'll finish by saying we know this type of behaviour is deeply gendered. Women, girls and gender diverse people are most commonly targeted, and most commonly targeted by men. A failure to criminalise the creation of this type of material is accepting a culture of gender violence where women's bodies are easily accessed and the property of all. In Australia, we have a problem with violence against women. More than 50 women have been killed this year alone by violence. We cannot allow women's safety to play second fiddle to men's interests once again. So I'll leave that there. Thank you.
Thank you very much. Ms. Lambert.
Thank you. And I'm speaking here today as the chair of the National Association of Services Against Sexual Violence. And I note that we are the peak body for specialist sexual violence services across the country, and representing over 120 services throughout the nation. Our member organisations work, closely with the other peak body services, including QSAN, who are represented here today, SASVIC, or Sexual Assault Services Victoria, who I am aware have provided a submission to the inquiry, which we have worked closely with them in order to inform our views today, and then also the Centre for Women's Safety in WA. The sexual assault services across the country support large numbers of people impacted by technology-facilitated sexual abuse, and they see firsthand the devastating impacts that it has on people's lives and ultimately their health and well-being as well. We are particularly concerned about the significant rise in the creation and distribution of deepfake materials. And we're also very concerned about the alarming increase in the rates of recorded sexual assaults, which can then also be distributed and transmitted across social media. And more generally, very concerned about the significant and disturbing rates of pornography, and particularly the increase in violent and degrading pornography. In general, NSASAF is very supportive of the amendments suggested, and agree with a number of the comments that have been made today. Our comments relate primarily to the aggravated offences in terms of the requirement for civil penalties. We certainly have some concerns that have been echoed here already by my colleagues today around the application of those and the issues that might arise around that. And would certainly agree that we think that bar is too high, particularly the idea that the civil standard had to be met 3 times. We would agree with the comments being raised already today around a standalone offence for creating deepfake material, and also the comments made around threats to distribute. I think that's been articulated quite clearly here today, how that can be used as a form of coercion and manipulation and perpetuating gendered violence. Aside from that, the main comments that we would add are around the need to consider other responses outside of criminal responses in addressing the issues of the creation and transmission of deepfake material. And in particular, the need to consider, as was raised already by Angela Lynch from QSAN, around the impact on specialist services. We already see a large number of people accessing services for support around these issues. The impact on people's health, well-being, their lives, and particularly their mental health cannot be overstated. And I note that this has the potential to impact not only women but also young people more generally, and we hear very disturbing stories about young people who've taken their lives as a consequence of being a victim of the sharing of deepfake material. I think it's important when considering young people to look at the impact that pornography has had more broadly, and the normalisation, I guess, of watching and sharing these kind of images as young people are so increasingly exposed to pornography at such a young age. So, we know, for example, a study in the Our Watch study in 2020 said 60% of young men and 41% of young women had used pornography as a source of information about sex and relationships in the last 12 months. So, that is certainly an area of concern. And within that, we see increased reports of non-fatal strangulation that's linked to pornography consumption, increased incidents of technology-facilitated sexual violence, increased incidents of recording of sexual assaults and the sharing of that, and increased use of pornography and threats to share images as a form of coercion in intimate partner relationships. The non-fatal strangulation is particularly a concern, and it is something that is regularly depicted in pornography and deepfake materials. We support the age verification initiatives, and think that's a really, really important part of the solutions. We also think there needs to be considerable investment into primary prevention that particularly is tailored to for messaging around technology-facilitated sexual violence, and safety education for all, particularly targeting young people. Also think it's important to look at developing pathways really to remove harmful images from social media and other platforms. We think it's important to look at investing in technology that can identify and remove deepfakes and violent pornography, and particularly child sexual abuse material. Agree wholeheartedly that there needs to be stronger requirements for technology companies and platforms that host deepfake, support deepfake, promote deepfake, and requirements for them to remove that material. And if there's some way to enforce takedown orders, then that's certainly something that needs to be considered. So whilst we agree wholeheartedly with the intent of the amendments, we do agree that there needs to be some consideration of how they can be strengthened, but also with recommendations around how this can be supported by other avenues to ensure that we address the issues. Thank you.
Thanks very much to all our witnesses for those opening statements. I'm going to start with some questions. As you all know, and you're very regular submitters to our committee, and I thank you again for giving evidence today. I'm going to ask some questions about provisions of the bill. That's what we've been asked to inquire on, but I am also going to ask some questions about the broader issues that you've raised, because I think they're important to get on the record. I've got some questions. I'll ask some questions about the problem or the harm that is being sought to be addressed, because I think that's important to understand and get on the record. I want to find out about the deficiencies in the current law. We should discuss those aggravated offences that you've all raised. I think that's important to discuss. And then there might be a chance before I hand over to other senators to talk about some of the broader issues in this space, because I think you've all raised important points about not just the criminalisation of the harm that's being caused, but where there might be other opportunities in other parts of law, regulation or reform to deal with the other parts of this problem. But can I just begin by asking about the harm and the problem? I think sometimes with women like yourself who work day in, day out with this issue, it's easily understood what the harm would be, but I really want it to be articulated for people watching at home what the harm of a deepfake pornography would be, particularly to the individual, but more broadly, I guess, to the problem of gendered violence. We might start with you, Noelle, and if there's something you've covered in your opening statement, don't feel like you need to go back over it, but if there's more information through the questions that you'd like to give us. How big is this problem? I've heard that it's exploded over the last couple of years. Exponentially is the word that's used. And what is the harm on the individual and the victim when this occurs? I might start with you, Noelle.
Yeah, so thank you so much for that question. In terms of how big the issue is now, I think it's reached an unprecedented level in terms of the scale and how many people can potentially be targeted, how easy it is to target someone, and how many websites are popping up that are dedicated to this abuse, literally dedicated to the non-consensual creation and distribution of deepfakes. In terms of how many apps are emerging that allow people to upload an image and it can churn out a naked image of like a woman, and so you can upload a clothed image of a woman and it will churn out a naked image. So these nudify apps are emerging. Billions of people have viewed, I believe, the top 40 non-consensual deepfake sites. So that's billions of people. Google and other search engines are directing traffic to these sites. Payment processors are, facilitating this trading. And so you've got issues that are happening in the news about celebrity women, but this is not something that just happens to celebrity women, as we've heard today. It is something that does happen to everyday women and girls, and we're hearing reports of it happening in schools where it's really actually child abuse material. But I really worry about how big this issue is going to get, given how easy it is to create this content, and the fact that there's like hardly any recourse and accountability for those involved in the pipeline. In terms of the individual implications for people, I think it is like life-destroying and shattering, and it is something that impacts a person in every aspect, from being able to find work, from being able to be employable, to be able to manage and control your reputation. It impacts your dignity, your autonomy, your agency. It compromises and threatens people's capacity to self-determine, to flourish, to exercise their sexual agency. And I think, you know, on a broader societal level, I really, really worry about what this means and what this is going to mean, I think, for our capacity to self-determine and for our capacity to exercise control over our lives and our livelihoods and our likenesses. And if we can't control ourselves without being sexually abused, then, you know, things will start to fall apart, I think. And I don't think it's an exaggeration to say that. And that's just, you know, one of the broader implications.
Sure. Thank you. And this new offence that's been created repeals the existing law that's in place, which is essentially framed around the sharing of private sexual material. And some of the submissions we've received, and even evidence that's been given from the Commonwealth Director of Public Prosecutions previously, have said the current laws themselves are deficient, because that a deepfake wouldn't necessarily be considered private sexual material. So that's why the entire offence is being repealed and recreated. I just wanted to ask about the deficiencies in the current law to deal with this problem of emerging AI technologies and deepfakes, and why is it... and the reason I'm asking this question is there has been some criticism that the current laws cover the problem, and you know, for me it's quite clear that they don't. On the way that the current laws are drafted and the way they're being implemented, why do we need to actually recreate a new offence which deals with deepfakes in addition to sharing private sexual material? I might start with you, Dr. Bergen, because I can see it ticking over in your mind, and perhaps others want to jump in on that.
Thank you. I think... if I may start by just saying, I think we're actually talking about a real spectrum of behaviour here. When we talk about image-based abuse, that might be, as we've seen a lot recently, kids in a schoolyard sharing what effectively is, child exploitation material of their peers and classmates. It can be a weapon of family violence, or it can be a stranger on the internet taking your likeness or an image of you and creating deepfake material. What's increasingly at risk here is that creation of deepfake material is more common, and AI is now in your pocket. It doesn't require skills that perhaps before used to be required. Technology has brought us along in that way. I think the concern that Angela raised at the beginning around this is an altered image, an image that didn't exist of an incident or a interaction or a pose or a whatever that didn't actually happen. This is new. This is something we're seeing as more common for the first time. It's been happening for a while, but on a different scale. This is going to start happening in schoolyards, in homes, as a controlling mechanism in a relationship. So I think the new bill is required to cover the changing landscape of image-based abuse and to capture the increasingly common creation of such material. But I would say that Angela's point around ensuring that a likeness is also captured would be something to address in the bill. And of course, the introduction of an offence of creation, not simply an aggravated offence of creation. The reality is people will and do create images of their partner as a mechanism of exerting control over them in a family violence context. So you can't leave because if you do, I've got these images. That might be an explicit threat. I will send these images out. Or look at these images I've created. And in the context of a coercive controlling relationship, that knowledge that the image exists is in itself an implied threat. I think that really amplifies the reason we need to act here is that the development and creation of images is something that we will see as increasingly common. We already are seeing it as increasingly common, which isn't covered by the existing law.
Yeah. Thank you. Well, I might go to you then, Ms Lynch, on this because you would see this in the context of family and domestic violence as well, but also with your expertise in these laws. As you're aware, this is a federal criminal code amendment. It relies on the constitutional communications power. So the criminal offence is based on transmission of these images. But what yourself and other submitters today have raised is the issue of creation itself is something that is concerning as well. On top of the offences and aggravated offences that are looked at here, one of them being an aggravated offence when someone creates on top of sharing, is it something that we need to look to states and territories under their criminal codes to criminalise the creation of these images as well? Just, recognising there are some constitutional limits to criminal powers that the Commonwealth can implement. Ms Lynch.
I obviously recognise that legal complexity, unfortunately. I think that, something has to be done because, the creation of the image or the material itself, it clearly should be an offence in itself, as Dr. Bergen has advised, especially in family violence situations where that creation really becomes an unsaid or an implicit threat or it will be an explicit threat that if you leave, I will release these. And that's very, very common. So I don't know whether it's it is very unfortunate that the whole raft of the offence cannot be dealt with in the one one piece of legislation, and then you're relying on states and territories and, goodness knows, a potpourri of different kind of legislation that sits around, whether there can be something through the national plan, through the meetings of attorney generals to get some real coordination under the national plan to end violence against women and children around this issue, and some consistency from the states as well, or whether it's a handing over of powers to the Commonwealth to deal with it under this. I'm not, I'm not a constitutional expert, so I don't know. All I know is that we want it, obviously we want the whole raft of the crime to be covered in a way that you're not dealing with one court and then another court and different legislation.
Yeah, thank you. Definitely appreciate that. I'm conscious I have to share the call with other senators who are very eager to ask you questions. So I'll just ask this question to wrap up, and I might have time at the end. Ms Lambert, you referred to, I guess, matters outside this bill. And to be fair to the committee, we're going to inquire and report on this legislation. But you spoke about a lot of issues that fall outside the bill, but could be looked at in other parts of reform, particularly around those aggravated offences. There's two aggravated offences as I read the bill. One is not just sharing these images but creating them in the first place, and that creates an aggravated offence. But the other relates to if someone has had a notice from the e-Safety Commissioner. How could that type of aggravated offence be improved in this bill? We're always looking. This committee is really proactive in looking for opportunities to make recommendations to improve what's in front of the Senate. On the aggravated offence, is there a way that we can look at, and we'll put these questions to the e-Safety Commissioner as well, but improving that aggravated offence so that it is more enforceable or has the possibility of maybe catching the behaviour that we're looking to criminalise? Ms Lambert, I'll start with you, and then if anyone else wants to jump in.
Yeah, thank you for the question. Look, I think that there's two things that come to mind for me is, I guess, the powers of the e-Safety Commissioner to be able to actually sort of identify and enforce those civil standards, and to issue those notices. So given the volume of the deepfake material that we are seeing, I think the capacity for that to be effective is, it is limited by the scale of the issue that we're talking about. And I think the other side of it is, and again, I would think that the issue of 3 notices is excessive. I think, in order to establish that concept of repeated and persistent disregard, then, I would think, does it really require a 4th offence to be before we're considering it an aggravated offence? The other side of it is as well, given that this is new legislation coming in, if we think about how long it would take for somebody to realistically be facing an aggravated charge like this, would possibly be quite some time as well, which means there'll be a considerable delay. And I think perhaps that in terms of it being a deterrent, I think that it's kind of limited in that context as well. So I think it'll be quite some time before we see anyone facing that kind of aggravated offence in real terms.
Thanks, Ms Lambert. I do have to share the call because I'm conscious other senators want to ask questions. I think I was pleasantly surprised that the bill deals with content that may have been created before the bill commenced, so that's good news. So just to clear that up, but it'll be related to conduct where the transmission occurs after the offence is created. So hopefully that will sort of try to capture some of that, but I take on board your views around the e-Safety Commissioner's powers, and we'll consider those as well. I'll just hand the call now to the Deputy Chair, and then we'll go to Senator Waters, who's joined us online. So, Deputy Chair, you have the call.
Thank you, Chair, and thank you to all the witnesses for joining us today, and thank you for all the work that you do in relation to this matter. Have you had the chance to review submission 13 from Professor Delfino of the Loyola Law School? Have any of the witnesses had a chance to have a look at that submission? I just want to quote to you some of the statistics from that submission, because we are looking at horrifying statistics in relation to the prevalence of this toxic practice. It is absolutely horrifying, the statistics reported here. So on page 1 of the submission from Professor Delfino, she submits more than 96% of deepfakes target women. That's the first point. And I'm going to seek your response to these statistics after I summarise them. In October 2020, further research from Sensity found that a new AI bot created and shared fake nude images of more than 680,000 women without their knowledge. A deepfake helpline in the UK had its caseload nearly double since the pandemic started. And and this is on page 2 of the submission, according to a report published in Wired magazine in the fall of 2023, at least 244,625 videos have been uploaded to the top 35 websites set up either exclusively or partially to host deepfake porn videos in the past 7 years, end quote. So from my perspective, I find those statistics absolutely horrifying. And there seems to be, as the Chair alluded to in her questions, an exponential increase in this practice. So I'm keen to hear from each of the witnesses as to what your experience is in terms of doing the wonderful things you do in the community and what you're seeing in the real world in relation to the increase in the prevalence of this toxic practice. So if I could go to first you, Ms Martin.
Yeah, thank you so much for that. And you know, when I hear you saying it out loud, it doesn't stop being alarming. The sad part is I'm so in this space that these numbers don't even shock me, actually. Well, you know, it's alarming, but I'm so used to it now. It is really, really sad to hear how many people are targeted. Yes, sorry, what was the question?
So that exponential growth, that is reflected in terms of your research, that this is this toxic practice is increasing in frequency almost at an exponential rate. Is that correct?
Yes, it is increasing, particularly since around 2017.
Okay, thank you. Dr Bergen, in terms of what you're seeing through your advocacy service, are you again seeing an exponential increase in relation to this toxic practice?
Yeah, absolutely. The Australian research certainly supports that it is increasingly common. And, you know, Noelle's right, you know, those numbers are you know, impactful, but unfortunately for those of us who deal in this work all the time, it's not shocking because we know it's increasing so much. I think it's also important to just flag the impacts of that on those individual victims and on society are significant. We know that the experience of image-based abuse, including deep fakes, makes women move off the internet, which means they have restricted access to the world that the internet brings, which is work, school, university, so education, but social bonds. So the significant impact on women as a collective is, I think, important to underscore.
Well, you make a very important point, Dr Bergen, about the impact on the individual, and I'll just provide another quote from the submission by Professor Delfino on page 2, and I'll ask Ms Lambert and Ms Lynch for your response to this quote. In relation to the impact on individual women, people who are the victims of this toxic practice, this is what Professor Delfino says. This takes a well-documented and real toll on victims' careers and personal lives. For example, one victim reported that after she was alerted to a series of deepfakes on a porn site that appeared to show her engaging in extreme acts of sexual violence, the images replayed themselves over and over in nightmares, and an all-consuming feeling of dread gripped her. She suffered panic attacks and was afraid to leave her home because of a feeling of shame and fear permeated her life. And then the paragraph concludes with this statement, quote, "Other victims have equated their deep fake pornography victimisation to their prior real-life experiences with sexual assaults and violence," end quote. So if I could just have your response, Ms Lynch, to to that submission, the fact that this is it's an act of violence against women when they suffer this sort of victimisation?
Absolutely. It's a misogynistic attack on the person and goes to the core of that person. It's vile, it's degrading, and it promotes a societal degradation of women. And it stops them from, as Dr. Bergen has said previously, and that quote refers to, socialising, engaging in community activities, leaving their home. The Queensland Sexual Assault Network over the last 15 years has seen the impact of pornography on the victims of violence that are presenting at their services, at the sexual assault services. The violence has become more violent associated with the actual act of sexual violence, and commonly involves strangulation and other forms of degrading violence. And also the victims have become younger over the years. And I think because our services have already wait lists, we've got 12-year-olds who have been raped on wait lists in Queensland. It's very difficult then, I think, for many of these other victims, if there hasn't been that actual physical sexual assault, to actually get assistance, because the wait lists are so long, and the services are under such pressure that it's quite difficult, I would think, for many of these victims to get assistance. Thank you.
And just in relation to that point, Ms. Lambert, the impact upon individuals who are subjected to this toxic behaviour can be catastrophic, it seems to me, in terms of the emotional impact, the impact on all aspects of their life. Is that your experience in terms of advocating in this space?
Yes, absolutely. You know, if you think about the impact on the individual, and, you know, as eloquently put in that quote that you read out, it goes across all aspects of a person's life. You have women who, they have no way of knowing who's viewed that material. Everywhere they go, that question sits in their mind. Have these people seen that? Do these people know? Family members, grandparents, extended family, co-workers, employers, you know, everyone that they meet and they come across, even walking down the street, have people seen that? You know, the impact of that is it's almost impossible to kind of quantify. So no wonder we have experiences where people don't feel comfortable to even leave the home anymore. So, and of course, that creates a huge amount of anxiety. I have situations, as indicated in that quote, around people having panic attacks, social anxiety, not wanting to leave anymore. And if you combine that with not wanting to be, so disengaging completely from the internet and all forms of social media because of the ramifications that's had, plus also not feeling like that they can look anybody in the eye anymore because that person may have seen the images that have been created. You've you've completely isolated that person from the world around them and from all relationships, even their close personal relationships and family relationships are not without impact. So whether they like it or not, they then have to tell people that in those personal relationships that this is what's happened, because otherwise that's something that's unsaid, which becomes a barrier within that relationship. And then they have to worry that if that person hasn't seen them, are they going to go and look for them? Do I have to tell them what's in that? The layers of this just goes on and on. So the impact on a person's mental health is entirely profound. And then in addition to that, We've also got, large numbers of women. We know what the statistics say about women who've experienced child sexual abuse and sexual violence. So large numbers of these women have a prior history of trauma and abuse already. So this experience is just compounding, re-traumatising, and it's just an experience of re-victimisation. So, very difficult to really quantify the magnitude of the impact on the individual, but profound is definitely what I would say. And never ending, it would seem for them, never ending. And they can never be sure that it's ever going to go away. In addition to that, I just would note as well, like looking at a community impact as well, which has been raised by some of my colleagues here today, but I think very important for us to come back to is the prolific rise in the creation and sharing of this material is having a very damaging and harmful impact on normalising violent sexual assault. And so the long-term impact of this in terms of the degradation of women and gender-based violence is also profound, and hence the importance for action now, not just in this criminal space, but more in the prevention space as well. Okay. And if I can make one last comment about the standalone offence that we talked about in terms of creation, and I recognise the limitations from a federal perspective around that. I think it is really important to consider how that might be, how we might work with the states and territories around that, because the message we need to be sending from a prevention point of view, if we really want to tackle this, is that creating these images is an offence. Sharing them is also an offence, but creating them is an offence.
No, yeah. That's a point well made, and it gives me a very convenient segue to move to the law in Victoria. So I don't know if you've had an opportunity to read the law which is on the statute books in Victoria, the Crimes Act 1958, which does include an offence with respect to creation that we're talking about. One of the issues that comes to my mind reading that Victorian legislation is the concept of consent, so the meaning of consent. The Victorian legislation, and feel free to take this on notice, and I'll seek any particular comments you have now, but sections 53P and 53Q of the Crimes Act 1958 in the Victorian Act contain some detailed provisions with respect to what constitutes consent and what does not constitute consent. And that includes the general concept of free and voluntary consent, but it also contains a principle of affirmative consent, so that so it provides in 53Q circumstances in which a person does not consent, and that includes where, subparagraph A, the person does not say or do anything to indicate consent to the production or distribution of the intimate image, end quote, and then it deals with other particular circumstances, including intoxication, where someone's asleep or unconscious, and it goes into some particularity with respect to what is consent and what is not consent, and that does differ to some extent from the bill which we're considering here. If I could just give each of you an opportunity to comment whether or not you have any concerns or other comments with respect to how consent is dealt with under the bill, and whether or not that is something which the committee should look at, and happy for you to take that on notice. So if I could start with you, Ms Martin.
Thank you. I think I'll take that on notice just for now.
Okay. Dr Bergen?
I may also have to take that on notice. I hadn't turned my mind to that issue. I would say I'm not aware of any criticism around the way the Victorian legislation deals with the issue of consent. But as we know from many of our times around the traps in these committees, that the issue of consent is extremely vexed. So it might be worth us taking that on notice.
I've been educated by a number of the witnesses actually on this panel in relation to these issues. So you've had a lasting impact on the way I see these things.
Yes.
Ms. Lambert?
It's possibly useful for me to come back to you on that one as well, but
okay.
Initial comments would be that I think the more clarity we can have around the concept of consent is the better, because it otherwise does provide an avenue for defence to question that. So, I think we've been very supportive about the concept of affirmative consent. And so I think it's worth considering how that could be applied in this context as well. But I probably should take another look at the Victorian legislation there. Yeah.
Ms. Lynch?
We would completely agree that it should be defined in the legislation, be explicit as possible. I think that the provision actually, so affirmative consent is about free, voluntary and informed. I'd actually say that it's in this crime that it's over and above that. It's actually, you would require some explicit consent, nothing implicit. I think explicit consent is required in relation to the agreement to transmit or publish this kind of material because of the nature of the material. I'd also want the provision of affirmative consent to ensure that it covers issues around coercive control and coercive consent, where victims really have no ability to say no. It's too dangerous for them to say no or not to agree in coercive control relationships. That may well be covered by that definition, but I would just want to highlight that, and I'd say it's over and above affirmative consent. It's explicit consent, explicit agreement that they are completely aware and informed of what they're agreeing to. That would be my...
And in fact, Ms. Lynch, you anticipated what's actually in the Victorian legislation because it actually deals in some specificity with the issue of someone not being able to give consent if they're operating under a fear of force or harm, and also if they're acting under coercion or intimidation, including a pattern of ongoing behaviour, which I think is intended to capture the issues you've raised. So happy to receive any further comments any of the witnesses have in relation to that particular point. Just a few other quick ones to take on notice, I think, so I can provide a colleague with an opportunity to ask questions. Firstly, in relation to aggravation and when aggravation might apply, it seemed to me that, especially in a domestic violence, gendered violence frame, that other acts of domestic violence, other misconduct which has been engaged in by a perpetrator should potentially be seen as aggravating the offence. So it might not well be something in relation to the dissemination of an image, but it might be some other act of domestic violence could potentially operate as an aggravated offence, because then it becomes part of a pattern of domestic or gendered violence. Could you consider that on notice in terms of whether or not aggravating circumstances should potentially look outside the prism of the actual what the Safety Commissioner does to other acts which potentially fit within a pattern of domestic violence?
That could be, Senator, that could be covered in the states that are criminalising coercive control or have criminalised it. Queensland have criminalised it, but it'll come in 2025. Specifically in Queensland, you can have a coercive control offence with another offence. So if these two offences could be joined, that offence can be joined up with the coercive control offence, and it's arguable that that can occur in New South Wales as well, which already has that, the criminalisation has come into effect on the 1st of July. So for some of those states, that is where there could be some assistance with that offence. But yeah, otherwise, I agree it is a circumstance of aggravation.
Okay, excellent. And if everyone else could take that on notice. And lastly, Google made a submission. I noted, Ms Martin, some of the comments you made around stakeholders, if I can put it that way, in relation to the publication of this material and responsibilities that they should have. Could I ask you specifically to take on notice Google's submission and provide any comments with respect to what Google has submitted to this inquiry? Is that possible?
Yes, I can do that.
Excellent. Thank you. Thank you, Chair.
Thank you very much, Deputy Chair. Senator Waters, I'm going to hand the call to you just because you're on video conference and not in the room. I'll give you the next sort of 20 minutes, and then if there's some follow-up questions from myself or the Deputy Chair, we'll ask some at the end, but you've got a good run of time. So, Senator Waters, over to you.
Thanks very much, Chair. And can I just check that the audio is okay? Because I'm hearing you guys, but it's not super loud. I've got thumbs up. Okay, lovely.
Yeah,
Thank you.
We can hear you.
Great.
Yeah.
Thank you. Apologies I'm not in the room, but welcome and thank you so very much to the people online, our witnesses joining us, for the work that you do in your everyday activities, but also for the time that you've given us today. I'm so distraught that this is just yet another front in the war on women, and I'm just genuinely. Look, I don't have technological expertise, so I confess this isn't an area that I feel very informed about. But I'd love to hear from you. How do we stop this happening in the first place? Yeah, Ms Lambert, you talked a little bit about how we need to do more prevention work. So I'd like to hear a bit more about the sorts of prevention that you think we need specifically to target this type of abuse. And I wonder, are there any other means that we as a federal level of government should be considering to deter this sort of activity? And this is where it veers off into areas that I don't have a deep understanding in, but are there any deplatforming of apps that could occur? Is there any kind of sanction that we might consider in relation to the Googles of the world distributing this sort of material? Like, could you just give us a broader perspective on what else we could be doing to stop this hideous, new, degrading, abusive form of violence against women that is totally non-consensual?
Look, absolutely agree with everything you've said. And look, I'm not a technology whiz myself either, but I would say that, you know, we do need to invest in looking for technological solutions that can remove materials for a start, but also we do need to, as Noelle mentioned earlier, create some accountability for the tech companies that promote and support this kind of material, including child sexual abuse material, I might add, but who at the same time deny any role in it or any responsibility. There needs to be some way to create sanctions or hold these organisations to account. And if there are penalties for them, that will have an impact. It really will have an impact. In terms of prevention initiatives, I mean, we look at primary prevention work with young people, starting with young people. I think we need some targeted, wide-scale messaging around the criminality of these offences. In addition to, there's a lot more primary prevention work that needs to happen in terms of the gender-based violence space in general, and we need to continue to do that. But I think it would be important for us to look at some early intervention activities as well, so targeting those kind of high-risk populations that we know are more likely to engage in this kind of behaviour, and develop some targeted early intervention strategies. And certainly that could be something that is looked at within the initiatives under the National Plan. And I think I think we do need targeted strategies as opposed to only wide-scale primary prevention. So we need both, absolutely. Yeah.
Just a quick follow-up, but I do want to hear from everyone else on that general question of what are some of the other lateral things we could do to reduce this. Is anyone doing that specific targeted prevention work? Has anyone been tasked with doing that, or is anyone of their own volition, any organisations already looking at that?
I think there's probably, in terms of community-led and or, sort of localised place-based work that's happening from specialist sexual assault services within some of the respectful relationship, or in addition to some of the respectful relationship works that they do with young people. But I do think there's probably a need to develop some specific early intervention strategies that, perhaps are a little, rather than just information-based, that are actually intervention-based. Yeah.
Is there any existing organisations that have that sort of expertise, or would that need to be a new body of work, a new outfit?
Specialist sexual assault services are very well placed to undertake that work. Yeah.
The education and prevention work with the potential perpetrators.
Absolutely, there's already, a number of sexual assault services across the country already work with adolescent males in relation to harmful sexual behaviour, and this kind of content is covered in that work, but that's mainly individually based. I think if we're focusing purely on the technology facilitated abuse, I think we can look at some group intervention work as well. So there's definitely a lot of scope there. Yeah.
Okay, so it sounds like that's a cohort that your sector is already working with, but this is sort of a new front in that abuse. So presumably you'd need additional resourcing and staffing to be able to scale up to address that.
Yeah. Yes, absolutely.
Is there anything in the national plan that could, it's a fabulous framework. The dollars need a bit of attention in my opinion, but is there anything that's already in the national plan that we could hang off to do more work in this space?
Sexual violence, yeah, is part of the national plan. So it's, yeah.
Sorry, Angela, Can you say that again? The audio is atrocious at my end.
Sorry, sexual violence is part of the national plan. However, it doesn't ever get, in many ways, the attention of that domestic and family violence gets. The issue of domestic and family violence is often prioritised under all of the different, under prevention and response and we would argue that there actually should be a sexual violence action plan, its own sort of standalone action plan, because of the failure to recognise and prioritise the issue. And in many ways, the horse has bolted. If sexual violence prevention services were listened to 15 or 20 years ago, we could have been ahead of the game, and now we're not. But if we want to actually intervene now, I think we need some concerted effort around the issue of sexual violence, and we need to be able to look at prevention. We would support, obviously an action plan would have prevention within it. There's just not enough focus or funding in relation to those issues, and also in relation to research. And we'd also ask for all sexual violence services around the country to actually be funded to do their own prevention work with their local communities. So we've got Our Watch that works at a national level, but we really need that kind of local kind of work as well. That just is not. At the moment, we're supposed to do prevention work, and there is some prevention work done ad hoc, but the response work takes over. You're pulled into response all the time, so it's very difficult to do that work. So it requires attention investment and prioritisation.
Well, I'm in support of that happening, so you've articulated the need for that really well.
Would I be able to add just a comment on that, if I may, just so you're aware, there are the National Plan Secretariat are looking at carefully at the prevention space at the moment, but I would agree with Angela that it's unfortunate that family and domestic violence it tends to prioritise most of the attention. It's important work, obviously, and there's an overlap with sexual violence, but there are some specific areas of sexual violence that really require their own attention. And just to highlight that there was some funding, some initiatives that have just been released recently around targeting young boys and who are at risk of potentially harmful behaviours. But it's very focused around domestic violence as opposed to looking specifically at the sexual violence. And again, we felt very strongly that sexual violence services would have been well placed to work with that population, particularly around the sexual violence. And there was an opportunity there, but we were excluded from being able to apply for those tenders.
What's the reason you were given for that exclusion?
The reason was just given that there was desktop research done that the providers that were invited were the best ones to be doing that work. So to me, that's really more about the fact that there's a lack of understanding about the specialist sexual violence sector and also the need for specific responses that are specialised in terms of targeting that. So, I mean, I don't want to hijack this process, but I think it's important to recognise that I don't want you to go away thinking there's nothing happening in that space, because certainly from the National Plan there are initiatives but there's nothing specifically targeting sexual violence. And certainly in terms of the issues we're talking about today, that is what's required, yeah.
Yeah, thank you. I think you've explained that very well. Noelle, please forgive me. I was stuck in traffic and I missed the benefit of your opening submission, but obviously I know of you, and what I did hear of how you've acquitted yourself today has been outstanding. So I'm keen to hear your views on the broader issue of how we tackle this. Sounds like this offence provision is, largely has been welcomed, doesn't quite cover the field in that it doesn't cover creation. But do you have any other views on what more should be done that is within the federal government's remit to try to stop this from happening?
Yeah, thank you for that question. I think what more needs to be done. Well, I think what we need to do to start off with is really and truly scrutinise the operations of the E-Safety Commissioner, of our regulator, because currently it's essentially the place to go and the body that is responsible for dealing with a lot of these issues. And we are seeing such an underutilisation and an ineffectiveness in the way that they operate. And yet we're also seeing this disparity between how they're operating in practice and the messaging that is being put out into the community that I think is actually parroted by a lot of the parliamentarians that we have. So I think we have to be really willing to scrutinise their operations and then reform it. I think from a survivor-informed lens. Something that I would love to see change as well in terms of the conversation and in terms of the way we approach this issue is that I would love to see a bit more of a shift away from removal as this ideal solution to tackle this issue. I think it's a fundamental part of dealing with this issue, which we're seeing now with the E-Safety Commissioner's operations, but also, in this broader space, this removal of deepfakes, this removal of intimate images that have been shared, but that is such a superficial response that does not tackle the root cause, that essentially just, pushes dirt under the carpet away from being discoverable. But you really need to tackle the root causes here. And perpetrators are not being held accountable. Tech companies are not being held accountable. They're allowed to enable this. They're not allowed to facilitate this. They're allowed to profit from it. And something that I wanted to add in terms of, the previous questions that you had asked, I've been in this space for a very long time, and this is a very niche space. And, with respect to kind of the other comments made, I have found it to be one of the most lonely, unsupported issues in the broader women's rights, victims' rights, survivor rights space. We are not getting the support that we need from any of the civil society organisations, from governments, from our institutions of power. So what survivors have actually had to do is organise themselves in this space. It is the survivors who have been fighting for this issue, fighting for stronger laws, speaking out in the media, speaking in schools. It hasn't been, I have not found in my experience that we've had much support from anybody else, really. It's the survivors who have to bear that brunt. It's everyday survivors who have now organised. And, even with this issue of creation, we're talking about now how, one institution said this about the inadequacies of the law. I just want it to be known on the public record that efforts to criminalise the creation of this abuse have been made years ago. And I know this because I petitioned the Australian government 7 years ago to criminalise the creation, in effect, the creation of digitally altered intimate images. And that petition ended up amassing over 44,000 signatures. So this fight has to be understood and appreciated for the unpaid labour that survivors have had to do, and we have not had support, quite frankly, from many of the people that we think would support us. So in terms of what we need to do to help them, I think you need to go directly to the survivors. You need to fund their organisations, their collectives, their coalitions, because at the end of the day, they've been fighting for this and they are not getting the support they need, and it's their lives on the line, their livelihoods on the line. So I would love to see that, and that's something that we're seeing lacking in the Australian response. I have fought for the e-Safety Commissioner to essentially establish a working group or something of survivors, to let them have a say, to be involved, to give them some sort of agency over their lives, but I have been ignored. So we need to look at how we can uplift and support the survivors on the ground, and we need to ensure that our policy recommendations are informed by survivor voices, and they get to have a voice, and they're consulted with as a way to deal with this issue almost from the bottom up.
Absolute agreement. I'm sorry that you've had to do this without the support that you deserve, and it makes what you've done all the more remarkable. But again, I'm sorry you haven't had the backing that you so desperately deserve, and I'm sure, having heard that, we'll all try to do better in that space. Rachel, I haven't heard from you, but I know my time's ticking. Can you, sorry for my questions being so all over the place, but is there anything that you want to contribute in terms of those broader approaches, whether it's deplatforming, something further to regulate Google's activities and the other transmission folk, stopping the creation in the first place, or any reflections on the plan?
Thank you, Senator. I'll start by just thanking Noelle for that impassioned response there, and absolutely back her in saying this, that sexual violence work generally is off the back of victim survivors. That's why RSARA even exists. So absolutely, and we do it unfunded. Noelle's done the work for at least 7 years unfunded, and Noelle, we're sitting here today having this conversation largely because of the work you've done, so well done for that. Not that lines your pockets as it should, but it's a thank you from us to you. Absolutely, what the core of what Noelle was saying there is that we need to not just focus on how we're responding. We need to tackle the creation of these images in the first place, because the harm is enacted at the point of creation. The creation of the image, whether or not the victim survivor is aware that the image is created, is the birth of that harm. To borrow from the submission of Professor Claire McGlynn, who's an international expert in this space, she talks about a survey by the Cyber Civil Rights Initiative, a survey of perpetrators of image-based abuse, who indicate that for them, the biggest deterrent would have been criminal penalties. So we've heard from the perpetrators' mouths what would have stopped them committing the offence, and that is a penalty. We often talk about the limitations of the criminal law as a deterrent or a preventative mechanism. It doesn't mean it isn't one. And in this case, the perpetrators are telling us it would have been the biggest preventer. So we need to listen to that, and we need to make sure we're acting, we have a robust framework to respond and to prevent that. But that also includes translating that to the community, that this is a crime, there are serious penalties. It isn't, you get 3, civil things you can ignore until, that's never going to happen. It's going to be very, very rare. The E-Safety Commissioner is going to, give 3 civil penalty orders that are all ignored, and then we have an aggravated offence. It's just ridiculous and not what happens in real life. Deepfake image-based abuse often occurs alongside doxing, so release of personal information. These are serious acts that have serious and real tangible impacts on their lives, but also on their physical safety.
Yes, I can imagine the terror it would instill.
Terror is the word. So I'll just flag that. The other thing, just on the broad prevention space, we need more than, signs at bus stops. What we're doing for prevention in Australia doesn't work. That's why we've had more than 50 women killed at the hands of men this year. Because prevention isn't working in the way we've thought about it, the way we've done it. We need actual meaningful investment to services. Sexual assault services are the most critically underfunded sector. Angela flagged 12-year-olds on waiting lists who've been raped in Queensland. That's not just Queensland, that'll be everywhere. If we think that it's okay for a 12-year-old to sit on a wait list for counselling, for specialist support counselling, that's the context we're in. Sexual violence is the poor cousin of family violence, but what we need to understand is that it requires a specialist response, but it's also a precursor offence to homicide. It's a serious risk factor for homicide, murder. We have to start taking it seriously. And we just don't. We haven't got a meaningful prevention framework for sexual violence. We haven't got a meaningful response framework. And survivors do this work, like Noelle here today, absolutely advocating her heart out for 7 years, doing a damn good job, but doing that damn good job for free. It's just not good enough.
I don't want to cut you off, Senator Waters, or Dr. Birkin, thank you. I did want to just quickly ask one question before we don't have these witnesses with us anymore. If you've got one more question, Senator Waters, and then I just want to put one other...
No, you go. Thank you all. That's been incredible.
Thank you very much, Senator Waters. And I did just have one question following up from the questions asked by other senators, and you spoke about this, Ms Martin, in your opening statement and in some of the answers. We did receive a submission from Google. We didn't receive submissions from other tech companies. I'll refer to, that, but without putting any commentary on reluctance to be involved in this conversation. There's currently a review of the Online Safety Act, which will report to government in October, as I understand it. That's an important review. But what is it that government or just regulators out there are not understanding about the way tech companies are approaching this problem? Is it that the problem is too big for them to deal with, or is there a lack of good faith in wanting to actually deal with the problem? Ms Martin, you might have a view on that. I'm sure others do too, but we have to be quick.
Oh, thank you. And something that there was the question about Google before.
Yeah.
I mean, look, these tech companies are public relations machines, and I was just rolling my eyes. I don't know if this is offensive in this inquiry, but at that submission, because it's just the typical, like, usual things that we hear from tech companies about what they're doing, what they're not doing. At the end of the day, we are seeing it on their platform. It has been on that platform for a very long time. These deepfake sites, high up on their search results. They know about it. They profit from it. It's like I get sick and tired of hearing the same excuses. And I think regulators need to stop going easy. Governments need to stop going easy. They've been able to operate with impunity for so long. And I think it's time that they are actually held accountable, face potentially criminal penalties, at least severe fines for what they've been allowed to do to people. And it's just not good enough that they're not actually held accountable in any meaningful sense.
Yeah. And if they're profiting off criminal conduct, surely, Dr. Bergen, that's something that we should be looking at as well. And that really concerns me, that not only tech companies are turning a blind eye, but they're actually making a profit from this type of material. Is that something that you would want the regulators to look at as well?
Absolutely.
Yeah.
Absolutely. At the end of the day, they don't care about the harm that's caused, because that harm, lines their pockets. And I think that's why we really do need to focus attention as well on that, preventing them from being created. And that includes the type of AI material that, makes it easy to make, and those, Noelle referred to one before, I think it's Nudify or something, where they, those types of things that support the creation. But absolutely, we need robust responses. We need to start, making sure that we're there's penalties for companies who are profiting off this criminal behaviour. And that's, if Google keep putting it up in their search engine as the number one result, isn't that distribution?
Thanks very much. We might leave that there, and I thank all the witnesses for attending today, for your submissions. I don't want to apologise on behalf of whatever airline prevented you from being here in person, Ms Martin, but I think a lot of travellers have been dealing with that over the last couple of days. So thank you for attending. We're sorry it couldn't be in person. Thanks for your advocacy over a very long period of time, and hopefully this is a good start, and we're making really good inroads in addressing some of these problems, but thank you for addressing the broader issues as well. That is all the time we have today. If you've taken some questions on notice, we'll give you a date to bring them back to our committee. Thank you very much.
Thank you. Thanks, Noelle.
And we're just going to have a very short, brief suspension while we get our next witnesses online. Thanks very much, everyone. Thank you for those following on today. We had an extended break because unfortunately we weren't able to get our international witnesses on the line. We'll seek to try to reschedule them if we can. But the committee is going to recommence its hearing now, and I now welcome the next panel that we were seeking to go to after the morning tea break. I now welcome Mr. Michael Bradley and representatives from the Sydney Criminal Lawyers via video conference. Thank you for taking the time to speak with us today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. Can I just see if we got Mr. Bradley there?
Yes.
Oh, thank you. And also Mr. VJ?
Yes, I'm here. I'm present.
Okay, wonderful. That audio is working fine from our point of view. But for the Hansard record, can I ask you each to state your full name and the capacity in which you appear today? We'll go to you first, Mr. Bradley.
Yeah, Michael Bradley, Managing Partner at Mark Lawyers and Director of the Grace Tame Foundation and Chair of Rape and Sexual Assault Research and Advocacy.
Thanks, Mr. Bradley. Mr. VJ.
Yes, my full name is Vinny, V-I-N-N-Y, and my surname is spelled Vijay, spelled V-I-J-A-Y. I'm the Senior Associate Solicitor at Sydney Criminal Lawyers.
Thank you both for joining us today. Do either of you have an opening statement that you'd like to make before we hand over to senators for questions?
I don't, thank you.
Thank you. Mr. VJ?
Yes. I'll make a brief opening statement. It's more off the cuff. I thank the committee for inviting myself to partake of the hearing. I'm appearing on behalf of my firm. I'm assuming that the committee would like to hear my perspective in terms of the amendments that are being sought. I can't profess to have a very intimate knowledge of the full details of the amendments, but I assume the committee wishes to hear my perspective. I've been practicing criminal law for a period of 8 years now, and obviously protection of the community is quite paramount when it comes to legislation such as this. Not only protection for victims, but also for people in the criminal justice system. I will say that in my practice, I have seen an alarming increase in terms of, an increase, I should say, of fake imagery being used in cases. I've defended a case actually just last year where I had a client who was alleged to have engaged in sexual acts behind his wife and was charged with criminal offences, and it was ultimately acquitted by the Court on Appeal. So there is an increase in this type of behaviour, and but I'm free to answer questions about my experiences in the criminal justice system and for my input into the legislation. That's all I have to say at this point.
Thank you very much, Mr. VJ. And can I just clarify, because it might assist the committee in asking you questions. I'm assuming, given that you're from Sydney Criminal Lawyers, you're practising in New South Wales, in the New South Wales jurisdiction?
Yes, practicing in the New South Wales jurisdiction. I also deal with cases in the Commonwealth jurisdiction, such as under the Criminal Code Act and the, for example, so yes.
Wonderful, thank you. And Mr. Bradley, I should know this, I'm so sorry, but whereabouts are you based?
In Sydney.
Okay, wonderful, thank you. I think from time to time there has been some questions about state jurisdictions and where there's an overlap in the criminal laws, so that will help us understand what we can ask you. We won't put any questions about Western Australia Criminal Code to you today. Thank you very much. I'll start with questions, and you would have, if you were following on from the hearing this morning, you would have seen we had a panel of women who practice in advocacy around this issue, and they talked about the harm that is that these criminal laws are seeking to prevent. I just wanted to ask about your understanding of how the law is currently framed. The Commonwealth Director of Public Prosecutions has previously given evidence to another committee saying that at the moment, the way the Commonwealth law operates, it's not clear whether it would cover AI or deepfake material. And I wanted to get your views, if you have them. If you don't, that's okay. You could take it on notice about the way that laws generally, but particularly this one, are needing to adapt to deal with this explosion in AI technology. Might go to you first, Mr. Bradley.
Thanks. Our observation is that this is a problem that is exploding, this is a good reform in that it's obviously taking this particular type of offending out of where it sits, which is sort of an aggravated form of a pre-existing offence that wasn't designed for this type of conduct, and giving it its own specific offence, which reflects what's already the case in respect of child victims. One thing I would note is that the offence is targeted only specifically at dissemination, which is what happens sort of 2 to 3 steps down the chain, we would suggest that there might be more consideration given to the steps further up, which are certainly creation and in many cases threat. So particularly in domestic contexts or relationship contexts, deepfake imagery as well as actual imagery or video content, sexualised content is often created in consensual conditions, but then the threat of usage can arise. That hasn't been specifically criminalised at this point, but we do know that the threat of dissemination is frequently a feature of sort of coercive control type situations, and is an act of abuse in itself. So that's something that's sort of still hanging out there, covered by state laws quite in some jurisdictions reasonably well, but it's something that the Commonwealth might also want to consider. And I think that the constitutional power would stretch to that, provided there's an intention. That's just something I thought I would raise.
Yeah, thank you. Just picking up on that, that's really interesting, and you've recognised there the constitutional realm that we are working within around the communications power. Happy for you to take this on notice if you want to give it a bit more thought, but in terms of that stretch, how would the Commonwealth consider doing that? Is there another type of criminal law, whether it's terrorism or another type of law that seeks to use the communications power to criminalise conduct that you could point us to? I know, I'm sort of thinking out loud here, but the term around using a carriage service comes up a lot under these types of criminal laws, because that's the power that the Commonwealth has constitutionally. But in terms of that stretch, it would be really helpful if you have a view on that, how we would be able to criminalise it if we could, or whether it's a matter of going and working with those states and territories that are lagging behind, because we often see particularly around sexual violence, and the work that the Grace Tame Foundation does in this space is a real shining light on this issue, that you really need to get all states and territories moving in the same direction when you want to criminalise an offence like this. So just your views on that.
Yeah, I mean, that's certainly true. I think it's both. Certainly, we want to see the states and territories moving uniformly in coordination with the Commonwealth to continue to address these gaps. We do think that the Commonwealth should be continuing to take the lead in those sort of coordination efforts. In terms of the constitutional question, I think there's a couple of ways potentially of approaching that. The creation of certainly AI content or animated content, for example, would necessitate the use of a carriage service anyway. So that's certainly going to fall within the constitutional reach. Where we're talking about something like threatened usage, I would think that provided that there's a purpose element that connects to use of the carriage service, then there's probably enough there. I mean, there's certainly, like in the terrorism realm, there's some pretty broad offences that pick up, that go, come well before dissemination, but still criminalise accessing and creating content for that purpose. So I don't think it's that much of a stretch, but obviously matter for the AGs to work out how far they can take it.
And Mr. Bradley, in the broader reform work that you do, and that the Grace Tame Foundation does, often sometimes setting or clarifying criminal law is really important for setting a standard for community behaviour. And what this law seeks to do, I think, is send a very strong message to lots of players in the tech space, but also members of our community, young and old, that this type of content is damaging and harmful, that there are victims, even though they're not as direct as it would be with revenge porn. What is the role in terms of the Commonwealth in setting that standard in terms of law reform and criminalising this type of behaviour? Will it also send a message to people in this space that this is something that is really damaging and can have long-lasting effects on victims?
Yes, inevitably. The critical aspect of the Commonwealth's role is that it is the it's the jurisdiction that can most readily regulate and bring some order to the internet, basically, using its communications power, but also recognising that the borderless nature of the internet and social media. So it's better placed than the states to change that paradigm of sort of lawlessness that in terms of how the internet and social media have developed. The signalling that this type of legislating includes is, we think, very important from both the community perspective, but also from the perspective of the corporate entities that control much of, or have the ability to control much of what happens online, and to date haven't really exercised that social responsibility very well.
Yep, I think that's a pretty fair comment. Mr. VJ, I might come to you on this first, and then Mr. Bradley, if you have anything to add. Just to be clear, I think this type of conduct and behaviour is awful and abhorrent and should be criminalised. But there's been some criticism of the aggravated offences that are included in the bill. Have you had a chance to have a look at those, Mr. VJ?
Yes, so I'm just looking at the bill now. So
So just more broadly, can I ask, because it is helpful for the committee to have this type of evidence on the record, what is the general purpose of an aggravated offence in criminal law, and when can they be applied, or when do prosecutors seek to apply them?
Yes. Usually prosecutors would seek to apply the aggravating factor at the very commencement of proceedings. So it would be at the filing of charges with the courthouse and service of the paperwork. So often prosecutors would apply the aggravating feature at the very commencement. So they would make it very clear in the indictment or the court attendance notice. Often, and the prosecutors bear a responsibility to identify the aggravating feature on the indictment so that the accused is on notice as to what the aggravating feature is. And so often it comes down to legal practitioners like myself to research that aggravating feature and apply to law to see whether the evidence bears out that aggravating feature. And often, if there is an aggravating factor, the prosecutors, if they have, for example, an uncertainty about whether that single aggravating factor can be substantiated beyond a reasonable doubt on the evidence that they've supplied, they may apply a backup offence, which is the simpliciter offence of the charge without the aggravating feature.
Yeah.
In terms of that. Yeah.
Thank you for that clarification, because this bill includes, as I understand it, provisions to allow that to happen. So essentially, if an aggravated offence is brought against the accused and it's not made out that the underlying offence would be able to be applied. Is that how it usually works in practice?
Yes, it would.
Yeah.
For example, if a person were to enter a plea of not guilty and the matter goes through various mentions or stages in the lower court or the committal proceedings and it goes to a hearing, the prosecutor has liberty to press both charges or both offences. So ordinarily they would present evidence as to the aggravating feature, whatever it may be, and if the aggravating feature is not found by a jury or the single sitting judge, if it's a judge alone trial or a local magistrate who's deciding facts, then if they cannot be satisfied with the main aggravating feature in the main offence, but they are nonetheless satisfied of the alternative or the backup offence, they may proceed to acquit or find the offence proven for the backup offence. So that it's like a safety net, for instance. There's a lot of prosecutors have discretion when it comes to presenting those charges once they do a review of the evidence. That's my general understanding of it, for instance. Yeah.
And on the aggravated offences in this bill, there's two as I read it. There is an aggravated offence which deals with where someone has been given notices from the eSafety Commissioner, and then when someone has not only shared this type of material but has created it as well. Aggravated offences are serious. There's an increased imprisonment or penalty attached to them. What's your view on the aggravated offences and how you practice, I guess, from the other side of people coming before the court? There's been criticism of the aggravated offences that the bar is set too high, and I just wanted to get your view on that as well.
Yes. In terms of if the first aggravating feature, for instance, if a person's been subject to warnings from the Safety Commissioner before, I wouldn't say that's necessarily a high bar. I mean, I believe the evidence would have to disclose that the person has been identified, they have been subject to a previous warning from the eSafety Commissioner. Obviously, in practice, it's a matter for where, in terms of the logistics as to how the eSafety Commissioner became aware of past conduct that led to the issuing of the warning in the first place. I mean, that does provide more leniency for persons in the criminal justice system where they can have a safety or like a warning issued by an eSafety Commissioner. But if they choose to not comply or re-offend, then that becomes an aggravating feature. There is another offence in criminal law at the state level, for instance, if a person's been charged with for example, a break and enter where they've been found to have committed such an offence before, there is a discrete offence which makes it more serious, or a separate offence that if they've been convicted in the past of that similar type of offence, they can be subject to higher penalties. So from an analogy perspective, I could say that, from my view, I believe that could be borne out from if the state wished to prosecute a person on the basis that there's an aggravating feature they've been subject to a e-safety commissioner warning before. Regarding the other aggravating feature as to production of material, ordinarily production does require proof from my experience, where it can be surmised from evidence, for example, where a person's videotaped another person and shared it, for instance. Obviously, there could be factual disputes about who held the camera, for instance, in terms of the production of that material, who took a snapshot. It can come down to just oral evidence about the circumstances of who took the video or who took the snapshot of the picture. Not in my experience, there's not too much investigation into the metadata associated with the production of images. I mean, just speaking from experience, I had a case where it was actually put in dispute that there was a photoshopped image, and the New South Wales Police received that. We've had to engage an expert to look into the metadata, and it was a bit inconclusive by the end of the case. But I believe production of material, for example, with child abuse material, there is a separate offence for producing child abuse material.
Yeah.
I don't believe it will be extraordinarily too high of a bar in terms of proof of that, but it would require a higher level of proof compared to some other offences.
Yeah, thank you for that. I'm conscious I need to share the call. I just want to go back to you, Mr. Bradley. We referred in passing to some behaviour of tech companies, and it's a point of discussion in this debate. I think advocates have been really clear about their views on the behaviour of tech companies, particularly on the profiting on sharing deepfake material, which is awful and hopefully will be stamped out by some of these laws and other reforms that are happening. I just want to take you to the bill. The offence that is created under section 474.17a, which is the new offence, which relates to the material depicts or appears to depict, which is the new way of describing this type of material, so whether it's real or fake. And the offence is using a carriage service to transmit sexual material without consent. And then I go to the interpretation of that definition, and it says that transmit includes make available, publish, distribute, advertise and promote. So a definition of transmission put in that way, do you think that that is going to be broad enough to capture some of the behaviour of the tech companies that are seeking to distribute, advertise and promote this type of deepfake material?
I'm not sure. I wasn't all that clear whether the intent of this particular bill was to sort of pick up the tech companies as well as the primary perpetrators. If that is what's intended, then I'd have to take that on notice. I haven't looked into that closely enough. But yeah, if the intention is to potentially be able to prosecute, for example, a social media platform for hosting this type of material or not taking steps to take it down, I'm not sure this goes far enough to achieve that.
Okay, and one last question that either of you might be able to clear up for me, and then I'll hand the call over. And this is genuinely a question because it's been a long time since I've studied criminal law. It was a long time ago, and I never practiced in it. With the underlying offence, the bill states that the penalty for the underlying offence is imprisonment for 6 years, and then the aggravated offence imprisonment is for 7 years. Can those penalties be applied cumulative, or is it one or the other? Or how would it happen in practice? Would it be more about the sentencing procedures in a state court?
I could answer that question. It could be done cumulatively. For example, in the New South Wales jurisdiction, I can't speak about, with the criminal code, there is separate provisions about consecutive sentences, but it can be served consecutively if there's more than one offence. So if a person's prosecuted for 2 offences, a court could set a period of imprisonment or a penalty which starts from a certain date and expires at another date, and the second sentence for the second offence could be partially overlapping, so what's called partially consecutive, or fully consecutive, where it starts from the end of the first order or penalty and finishes at a future date, for instance. So a lot of offences in the criminal jurisdiction, when magistrates or judges pass sentence, more often than not, they tend to be concurrent, so that when a person's sentenced for 2, 3, or 5 or 6 offences, all the orders start from the same date, and different sequences or different charges may have different finishing dates to reflect the objective seriousness of the offence or the circumstances. So meaning that more serious offences will have a longer period of an order, such as prison or some other court-sanctioned order, to reflect the objective seriousness, if that assists the committee.
It really does, and it may be a question that we put to the DPP when we have them in front of us as well. But thank you. I want to hand the call over to the Deputy Chair. Thanks.
Thank you very much. Thank you to the witnesses for appearing today. One issue which we haven't touched, either with yourselves or with the prior witnesses, is the potential application of the offences to children, and the application of the offences to children has been raised by a number of witnesses. In relation to those concerns, the National Children's Commissioner, Anne Hollands, raised concerns in relation to the potential application of the offences to children. And I just want to quote from her submission: "We've allowed the regulation of the digital world, the online world, to be so weak that it allows kids to do things or get involved in these negative actions that have terrible consequences on others." And she further noted that she had a concern about the potential application of the offences to children but under the age of 14, potentially. And I further note, just by way of background, that the Victorian legislation that deals with creates similar offences and also creates the additional offence of creating an image, actually has a section in it, section 53W, which provides that, and I'll just read the section to you: "A prosecution for an intimate image offence must not be commenced without the consent of the Director of Public Prosecutions if the alleged offender is under 16 years of age at the time of the alleged commission of the offence," end quote. So there's an extra step in the Victorian legislation if the alleged offender is under the age of 16. I'm aware under Commonwealth law that, as I understand it, if an alleged offender is under the age of 14, then there's an additional evidential burden for the prosecutor to prove that they understand what they're doing is wrong before an offence can be proven under Commonwealth law. Given all of that context, and the concerns that have been raised. I'm just interested in both of your perspectives with respect to what this committee should consider in terms of the application of the offences to children. So if I can go to you first, perhaps Mr. Vijay.
Yes, thank you. It is true. I mean, what the overseas, I think it was quoted that it was in Holland that obviously with children being on the online sphere, I mean, just talking from experience, a lot of children of high school age would engage in social media. There will be online harassment and bullying, for instance, and so it is quite unregulated. I can't speak as to the social media companies bearing responsibility for online behaviour. Obviously, they would have policies in place to regulate that type of behaviour, but it could be ineffective at the same time as well. But the law does afford additional protections for persons who are children. So what was spoken of in terms of if a person under Commonwealth or state legislation is between the age of 10 and 14, the presumption of what's called Dolly Incapax applies from a legal perspective, meaning that the state bears a burden to prove beyond a reasonable doubt that the young person knew what they were doing was seriously wrong, as opposed in a criminal sense rather than morally wrong. So if, for example, a young person found a toy inside a jar, which is like a prize jar in their grandmother's basement, and they smashed the jar to get the toy, they may not realize that what they're doing is a seriously wrong thing to do in a criminal sense. They may think it's just part of fun and games, for instance. So, and that's what the law reflects, that if a person is between the ages of 10 and 14, the state bears a burden to prove they knew what they were doing was seriously wrong in the criminal sense. So, and obviously from ages 10 below, that's when a young person cannot be prosecuted generally for a criminal offence, since they fall below that threshold age. And then from 14 onwards, they're still culpable for offences as an adult, for instance, by way of evidence and the ordinary measures. That's aside from the fact that young persons will be prosecuted in the children's court jurisdiction for state offences. In the Commonwealth sphere, or maybe a different question in terms of which court they're before. But that's generally how it applies to children. Obviously, it is a concern given that children may be more susceptible to engaging in online harassment or bullying, or engaging in offences such as deepfake pornography, whereby they may manipulate images using online software that's becoming more freely available to harass their schoolmates, for instance. In terms of the other question where the Victorian legislation speaks of the prosecution not commencing an offence against a person under the age of 16 without the consent of the DPP, there is similar scope in the New South Wales DPP as well. I believe that it more has to do with a direction, what's called a direction under state law, where a senior DPP representative has to provide approval for an offence to be laid. There are some New South Wales offences where a direction that I've just spoken of is required before they prosecute a particular offence. Sometimes it could be to do with the fact that dealing with children can be a more sensitive issue. There are more stakeholder requirements, such as consulting with the Departmental Family and Community Services or Youth Justice, for instance, and other stakeholder organisations. A DPP representative may be able to speak more in depth about the requirements for a direction or consent from the DPP to be required before prosecuting an offence against an underage person, for instance. But that's my general understanding about the additional protections or given to young persons or the extra legal steps that are required.
Okay, thank you. Mr. Bradley, do you have anything to add?
Just that, my firm's on record supporting the campaign to increase the criminal the age of criminal responsibility nationally to 14. So that's our view generally on criminalising conduct of children. I think that, as a general comment, if children are involved in creating this type of material, which we know they are increasingly, whether the victims of that are other children or adults, then a criminal justice response to that isn't the effective one, and not the appropriate one. We've got much deeper problems where children are engaging in this type of conduct, and we've already seen widely reported instances of that, and that's a problem that's just blowing up.
Yep. Okay. All right. I've just got one other area I want to ask you both a question in relation to from a technical legal perspective, and feel free if you want to take this on notice to further reflect. You'll be aware that the general scheme under the bill is you've got and there's probably a technical criminal law term for it, you've got the basic offence provision, and then you've got elements of aggravation or aggravated offence provisions. One of the aggravating matters is creation. So if you created the image that was transmitted, the bill specifically says that if the transmission occurs after the bill becomes law and it can be proven who actually created it, so the alleged offender is subject to a conviction that they actually created the image. It doesn't matter whether or not the creation occurred before this law comes into effect or after. So that raises a question of retrospective application of the law in the particular context of the aggravating offence. In response to that, in the explanatory memorandum, the issue is dealt with in relation to the statement of compatibility with human rights. And I'll just quote this to you to give you an opportunity to reflect. The application of amendments provision in the bill provides that the amendments will apply in relation to material that is transmitted, made available, published, distributed, advertised or promoted after the commencement of the schedule, regardless of whether the material was created or altered before or after the commencement. This is necessary because it would be impossible for the prosecution to prove, based on admissible evidence, precisely when material was created or altered and whether that was before or after the commencement of this bill. However, this is appropriate given that the prosecution will still need to prove that the transmission of the material, that the material is sexual material, and an absence of consent occurred following the commencement. So the statement of compatibility with human rights deals with the issue of retrospectivity in that particular context and provides an explanation as to why it shouldn't matter whether or not the image was created before or after the law coming into effect in the particular circumstances of this case, because of the difficulty in proving when an image was created. So, interested in your views with respect to that particular issue. So, Mr. VJ?
Yes, so retrospectivity does create issues in terms of a human rights perspective, in that it can be quite unfair against an accused person who is presumed innocent until proven guilty. It can be quite unfair by creating retrospectivity where that at the time they committed the offence, it wasn't an offence to begin with, and it's a backwards application of the law to make what they've done in the past a criminal offence. That's not to say that that cannot be done in the sphere of criminal law, a lot of sex offenders have been prosecuted for things that happened in the past, and different legislation would be applicable to the offence depending on the time that the offence was committed. But it can create some unfairness to the accused in terms of the accused's knowledge of the law at the time, whether they knew they were doing a criminal offence at the time. In my experience with sexual offences, for example, under the New South Wales law, there's a charge of an adult maintaining an adult relationship with a child, or what used to be called a sexual abuse charge, which does carry a life imprisonment charge. I think there was a High Court case that went before the court earlier this year, where it was left to the High Court to decide whether the higher maximum penalty of life imprisonment applied to this offence, which goes back in time to, say, 10 or 15 years. So, and ultimately they did decide that the life imprisonment penalty applied rather than, say, a 15-year offence or 20-year offence, I should say. So it does create issues in terms of unfairness to the accused. That's something which could be made more explicit in the legislation, or the bill, I should say. In terms of proof of when a image is created, usually in terms of proof, it falls down to evidence as to when a witness or a victim says they received an image or created an image. Ordinarily, from my experience, to prove when an image was created, it falls down to analysing the metadata. So it can be analysing the metadata of the image or the video, for instance. So it could be as simple as right-clicking the actual electronic file, going through the properties. It will have a modification date, a creation date, and often that times can actually be unreliable itself, in that sometimes if a different program opens up that same media file, it could actually change the creation date, or it may be off by several days or several weeks, for instance. And sometimes proving the creation date of a file may involve the work of a IT expert who would forensically examine the file and the actual device itself, such as a laptop or a media tablet or electronic tablet, to find the creation date. So in terms of proving when a file was created, it can be done by forensic analysis and just anecdotal or witness testimony or evidence as to when a file was created. I hope that answers the question in that regards.
Okay, Mr. Bradley?
I can just say that, I mean, the bill doesn't criminalise the creation of material, so I don't really see a retrospectivity issue there. And obviously in many cases with adult victims, the wrongdoing won't relate to the creation itself. The wrongdoing is the breach of trust that's involved in later disseminating material that may have been consensually created in the first place. That would be a relatively common fact situation. In which context the fact that the person doing the disseminating had created the material in the first place should naturally be an aggravating factor, but it wouldn't create any unfairness. So I don't see an issue.
So there's no issue just to be clear, there's no issue from your perspective as someone who practices generally in this area if the aggravating factor occurs before the creation of the offence, because the offence itself occurs obviously after the law comes into effect, and that's the key point.
Well, yeah, I mean, I would say that the aggravating factor, in fact, still occurs after it isn't retrospective, because it's not the fact of the creation. It's the fact of creation combined with what the person has then chosen to do with the material subsequently, that involves a violation that is greater than in other situations where, for example, it was a stranger.
Okay. Okay, thank you. Thank you, Chair. That's all I had.
Thanks very much. That's all the time we have with this panel, and thank you very much for your attendance and for your evidence today. We really do appreciate it. Thank you for your insights. That is all the time we have for this panel, so we'll move on to our next witnesses who have kindly brought forward their attendance, so we thank them very much for that. I now welcome via video conference Professor Asher Flynn and Professor Jonathan Clow. Thank you both for being with us today and to speaking with the committee. Information on parliamentary privilege has been provided to you, and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you each to state your full name and the capacity in which you appear today? We'll go to you first, Professor Flynn.
Sure, thank you. So my name is Asher Flynn and I'm appearing as a Professor of Criminology at Monash University.
I'm Jonathan Clough. I'm appearing as a Professor of Law at the Faculty of Law, Monash University.
Thank you very much for both being with us today. Do either of you have an opening statement you'd like to make before we go to questions from senators?
Yeah, I've got a few points I wanted to raise. I'm not sure if, Jonathan, you have as well.
You can start first, Professor Flynn, and then we'll go to Mr. Clow. Thanks.
Sure, thank you. So I wanted to start by thanking you for the opportunity to speak today and to acknowledge that I do believe that this bill is a positive step towards recognising the potential harms and the increasing occurrence of sexualised deepfake abuse. So we conducted a study almost 5 years ago which identified the emergence of sexualised deepfake abuse across Australia, the United Kingdom and New Zealand. And at that point we were seeing around 14% of our over 7,000 respondents acknowledging that they had experienced it, and around 8% of people acknowledging that they had actually perpetrated this type of abuse. More recently this year, we've been conducting interviews with victims and perpetrators of sexualised deepfake abuse, and this research, combined with other research that's been coming out, is suggesting that there are more and more examples of these forms of abuse occurring, and that problematically more access to the tools to create sexualised deepfake content without necessarily having the skills or the computer equipment, just using an app or a website, are becoming readily available. I want to stress that the harms of sexualised deepfake abuse are the same as those experienced with what you might call real, non-consensually shared sexual images. So these can include quite significant physical and mental health harms, including suicidal ideation, as well as things like becoming hypervigilant, experiencing isolation, reputational damage, etc. So we have had very few studies looking at the motivations behind this, but our research suggests that perpetrator motivations vary widely. So it's important that the bill is able to capture these. So some of it is about directly wanting to humiliate and harm the victims, but others are doing it for exploitative purposes, for example, through sextortion and blackmail. The other key things that I wanted to mention is that this is rapidly spreading, and the accessibility of the tools to create these types of imagery is normalising the practice of sexualising images, particularly of women and girls, without their consent. So there is a real risk, without taking serious steps like criminalising deepfake abuse, that we will see backwards efforts in our attempts to address and prevent sexual harassment and abuse. Now, with all of this said, I think that the law does a good job in sending a clear message that we don't tolerate this type of behaviour, and it does send a clear message to the states and territories, particularly that they should step up as well to recognising the harms of deepfake abuse. But I do believe that the current proposal has left two substantial gaps, and that these should be addressed potentially by utilising the current laws operating in Victoria as a framework. So the first point is around not including a standalone offence of creating a deepfake sexualised image without consent. I believe that this does leave a gap in situations where the image may have been created but not shared. There are still significant harms to an individual from the creation of that image. So in Victoria, this is addressed by including digitally creating the image in the definition of producing intimate images. I appreciate there are some difficulties with this as a federal law, as it needs to link to a telecommunications service. But I did note in Professor Delfino's submission that the change could perhaps be introduced through including create under the definition of transmit. So I think that's something to consider. The other main gap is around not including any type of offence relating to the threat to create and or distribute a sexualised deepfake image without consent. So much research has shown that it is not uncommon for perpetrators to threaten to create or distribute images regardless of whether that image actually exists. So again, the law in Victoria could be used as a starting point here, again recognising there needs to be a link to the telecommunications service. The final points I wanted to make is that I strongly believe that any type of bill that is introduced needs to be supported with education and awareness raising campaigns. I think this needs to include a focus on the penalties of the law, but also include a clear focus on the harms and creating awareness of why it is necessary to criminalise these types of behaviours. And the final point I'll make, if time permitting, is just that while we recognise that humans are the ones who are making these decisions to use the apps and to create the technologies, and we don't want to absolve the people involved from engaging in criminally harmful behaviour, I think it's also important that we are remembering to include a focus on technology providers, platforms and developers to be answerable to community standards and to remove apps or technologies from their platforms where those are promoting criminally harmful behaviours. And I think that in order to do this, we need to think about tightening regulation on advertising tools that are encouraging people to engage in these behaviours, and think about how we can ensure the eSafety Commissioner has the powers and resources to hold tech platforms, developers and providers accountable. So thank you for that opportunity.
Thank you, Professor Flynn. That was really informative. Professor Clow, an opening statement before we go to questions?
Thank you, Chair, and thank you also to the committee for the opportunity to speak on this significant amendment. My comments are focused on the legal operation of the provision, although I'm broadly supportive of the idea of bringing sexualised fakes within the ambit of the criminal law. I think there are a number of positives in relation to these proposed amendments, in particular that it, broadly speaking, operates within the existing framework, that it builds upon the Online Safety Act framework by having civil penalty orders as an aggravating factor. It is limited, in my view, it's a positive that it's limited, it's relatively limited in terms of retaining transmission and incorporates generation and creation as an aggravating factor. It incorporates subjective fault elements, which is important for an offence of this seriousness, noting that the penalty for the primary offence is 6 years imprisonment maximum. However, I do think there are some areas where it is potentially ambiguous and potentially overbroad, and it's very important in an offence of this seriousness, as we're all aware, to appropriately balance the interests of prosecuting such matters with the interests of an accused and other relevant interests. So just noting a few key issues, and some of these were identified by the Scrutiny of Bills Committee. There are definition issues. So the Scrutiny of Bills Committee identified sexual pose, but identify what I think is a more significant definitional issue, and that is sexual material itself. It is clearly, the offence has evolved over time. It appropriately includes sexual deepfakes, for example, and the intention is clearly to restrict that to realistic fake material. And that's appropriate given that that is seen as equivalent to what may be seen to be real images. That's clearly the intention, but it's not clearly set out, it seems to me, in the provision itself. The provision talks about depicts or appears to depict, and on my reading and the ordinary meaning of those words, that does not necessarily require that the image be realistic, and I think that's something that could possibly benefit from review. The second issue, as has been noted by the Scrutiny of Bills Committee, is the creation of this new offence. First of all, divorces it from section 474.17, which would require proof of menacing, harassing or offensive. That is no longer required. It also removes the requirement of a reasonable expectation of privacy. So what we now see is that the offence itself, the gravamen of the offence, is the transmission of sexual material without consent, intentionally or recklessly. However, on my reading, this does not require the prosecution to prove an absence of consent. That is not actually an element of the offence, and particularly where recklessness includes a person not turning their mind to the issue at all, it cannot necessarily be inferred from the mental state. So it seems to me there's a question of consent being brought into the offence itself as absence of consent rather as an element of the offence, or possibly expressly as a defence. Thirdly, the committee also noted the placement of defences on the accused, the evidential burden, particularly in relation to whether a reasonable person would consider the conduct to be acceptable. It seems to me, in looking at the guidelines for the drafting of offences, there is an argument that those matters should actually be an element of the offence rather than sitting within the defence. That would be consistent with the position in other jurisdictions, including in Victoria, where the relative standard is an element of the offence rather than a defence, and I think that appropriately places the balance on the prosecution. I would agree with Professor Flynn that I think a threat offence would be desirable to incorporate. And finally, and building upon what Professor Flynn was saying, and this doesn't detract from the amendment, but this is part of an important ongoing discussion about the tolerable limits of material that's available online. I note that this is limited to sexual material only. There is material which may be humiliating, which may be repugnant to a significant degree, but which is non-sexual and which is not incorporated and would fall possibly within other provisions, but it may be consideration for the future of ensuring that material is brought appropriately within the criminal law. Thank you.
Thanks very much for those opening statements. I've got a couple of questions I might ask, starting with you, Professor Flynn. I wanted to ask a little bit more about the research that you've conducted. We had a lot of really helpful evidence this morning about the impact that this type of conduct has on victims and how it can be incredibly damaging and harmful to them. You mentioned in your opening statement a bit of research about perpetrators and the motivations of perpetrators. I was wondering if you could talk to us a bit about that and what your research found, so that we can sort of try to understand why this is occurring, why people are doing this, and how it's being used to threaten or affect the victims that are eventually harmed by the conduct.
Yeah, sure, thank you. So there are a range of motivations that we've identified in speaking with perpetrators, and some of these range from the more harmless in thinking that they're just having a bit of a joke or having a bit of a laugh. That's often in the context where the behaviour that they've engaged in is against when it's a male committing it against a male friend. For example, we've had several participants who spoke to us about doing it in the context of like a bucks party and creating a sexualised image or pornographic video as a joke of a friend, not thinking about the potential consequences of that, right through to having people acknowledge that they are doing it in the context of a relationship breakup or in order to harm, humiliate or control the victim from not leaving a relationship or to ask them to engage in some type of sexual activity or to give them something in exchange for either not sharing that image with other people or not creating that image in the first place. We've also had some examples of it happening outside of the context of intimate relationships, intimate partner relationships, but we've had a number of victims report to us that they have experienced it within the context of meeting someone online and then engaging in just not even a sexualised discussion, but having a Zoom or a FaceTime conversation with them, thinking that it's just a normal one. And during the course of that, it's been recorded and then they've been threatened with the fact that they're going to turn that into a sexualised image unless they pay money, unless they engage in some activity for them. So there's a range of different ways we're seeing it play out that recognise that it is kind of a broad church of motivations that are leading to this. The importance of having a threat offence is that it is able to capture those contexts where it is done in the form of a coercive controlling behaviour, but also in regards to those sextortion and blackmailing offences, which we are seeing increase, and we have seen them continue to increase substantially since COVID-19, when our lives were essentially turned online.
Thank you so much. I wanted to ask you, I think it's really helpful to understand how this is being used in a broader concept and in the context of coercive control, family and domestic violence, sextortion. There was a case recently of sexually explicit images that were created using AI of students and teachers that was shared online. What does your research tell us about the information or education campaigns that are targeting particularly younger people about this, and whether there's a gap in that as well that we're seeing?
Yes, certainly. There's absolutely a gap in education around this, and it's about raising awareness, I think, of what the consequences of these images can be. So the examples that you spoke about happening in the schools with students creating them of other students and of teachers has long-lasting implications and impacts for those people. It essentially normalises the sexualisation of young girls and women, which is highly problematic, but it also is creating a space where the education that we've had in schools, which has been really positive, focusing on respectful relationships, but a lot of the education around image-based abuse or things around sexual consent and imagery has been related to this idea of, oh, don't share images of yourself, or don't share images with your face in them, or things like this, which isn't exactly a great way to respond to a situation where young people are consensually sharing images as well. But what we need to be doing is providing more information as to what the harms and implications of actually creating a sexualised fake image of someone is, whatever the purpose for that might be. And I think that is something that we're certainly not seeing. In the interviews we've done recently with victims and perpetrators, even those who were within the sort of 18 to 21 year age mark that you would argue, recently completed school, said that they didn't learn anything about this in their schooling context, and that it's just something that people were doing, but there was no education around what the harms or issues of that were. And I think given that we have the tools so rapidly available, like there's adverts, you can be on Instagram and across your feed will come adverts for creating fake images using AI of other people, and they can very explicitly say you can make a girl do anything you want, and they're freely available, being promoted across our social media platforms. So we do have to look at how we can increase education around that, but also how we can prevent that type of advertising and the tools being readily available, not just for young people, for everyone, but in particular for our younger community.
Okay. And I guess stepping through that, that this is something that's not necessarily talked about or it was happening but not necessarily identified, does criminalising this type of behaviour through the Victorian law has an example, but we're also doing that now through this legislation that's being proposed. Does that set a standard for the community and for particularly young people so that they understand that this is harmful behaviour and that it is so harmful that it's actually being criminalised?
I believe it does send a clear message that we're saying as a society we don't tolerate this behaviour, that it's wrong, that it has harmful implications, and that we believe and support people who are experiencing this type of abuse. But I do think it's really important, and sorry, just to clarify as well, we have seen that with some sort of reduction in the way that image-based abuse is happening, for example, in younger communities. So there's more understanding of getting consent before you share an image, or deleting the image once you receive it. So we are starting to see the fact that laws were created back from, almost 10 years ago now. So 5 to 10 years, we've seen an implementation of laws around image-based abuse itself. We're starting to see implications from that coming out. But I think that it's really important that with this law being introduced, that there is some kind of education and awareness raising around it. That was something that was done really well when when the e-Safety Commission Victims Reporting Portal, for example, was opened. There was lots of billboards, there was ads on like YouTube, there was lots of information like that. So I do think that, yes, this will send a message, but we have to also make sure that that message is being promoted and people are raising awareness as to these are the consequences, but also this is why we're doing it, because it's harmful and it's something that we don't tolerate in our society.
Yeah, thank you very much. Just one question to Professor Clow and then I'll share the call. You, in your opening statement, you referred to some questions you had about the intent of the bill or the way that it's going to operate in practice. We might put some of those questions to the DPP or to the department that's drafted the bill to get some clarification around that. But in terms of the way the offence is set out, the way I see it is the repealing of private sexual material as an offence, which I'd loosely call sort of a revenge porn crime. Taking that out of the criminal code and bringing in this new offence that takes out the offensive part, the humiliation, the menacing part, and links it to consent. Do you think that's a positive step forward? Like, I think for me, what it's doing is broadening out the concept of sharing explicit images without consent. But how would you think we'd make that clearer, that is actually what the intention of the bill is trying to do?
Thank you for the question. I do think it is a positive step, and picking up on Professor Flynn's research, where you have an equivalence of harm, then it's important that it's treated in the same way, because that would be an initial question. You could, of course, criminalise the fake material separately and create a separate offence just for that material. Here we see a conflation of the two. This is also true in Victoria, which has gone through the same sort of evolution so that the requirement of privacy is removed. I suppose what I'm emphasising is, and given the seriousness of the penalties imposed, when the gravamen of the offence is the non-consensual transmission of that material, it's important that the material is very clearly defined to be realistic, because my understanding is that is the intention of the provision. It's in a note to the provision, but it does not, to me, clearly appear in the body of the offence itself, that any depiction must be realistic, because that's where you have the equivalence of harm. This isn't cartoons, this isn't crude photoshops, these are realistic deepfakes. That's my understanding. And to me, it seems that could be clearer in the wording of the bill beyond simply depiction. Also, the idea of bringing consent up front, that this is transmission without consent and that is required to be proved, rather than possibly being one of the circumstances in a defence, seems to me making at the forefront of the offence, this is what we are criminalising, this is why we are criminalising, this is why it is such a serious offence, that you have, without consent, transmitted material of the sexual nature, knowing or reckless as to it being without consent. Does that help?
Yeah, it really does, thank you. And I'm going to hand the call to the Deputy Chair. I'm sure we've all got lots of questions for you both. Senator Scarr?
Thank you, Chair. And thank you, both of you, for appearing today, and thank you for all the wonderful work you're doing in this space. It's greatly appreciated, and it's very, very useful for us. Professor Clough, can I just probe that comment you just made in relation to realistic deep fake images? We did receive evidence earlier today from Ms Lynch, who is Executive Officer of the Queensland Sexual Assault Network. And Ms Lynch actually put the contrary case, and that is that the bill perhaps doesn't go far enough in terms of its scope, because from her perspective it doesn't include avatars, animation, alter egos and other images that might be made to look or present as if they are a particular person, but on their face they're not a realistic image. So that was the point that Ms Lynch made from the other perspective. The point you're making is the bill's not tight enough in terms of defining its scope. So perhaps this is a definition. Perhaps this is an argument over what should the scope of the bill be, and should the scope of the bill actually extend to include avatars, animation, alter egos, which can be, of course, humiliating and degrading and very disturbing in their own right. Can I give you an opportunity just to give your thoughts and reflections on that point?
Certainly, and I broadly agree with the point, and it's why I made the comment at the end that I think there is a broader discussion of how we treat material that is non-sexual, maybe humiliating, maybe degrading, how we consider that. My comments in relation to this bill is the way that it is structured, and picking up on Professor Flynn's research, is my understanding is that the suggestion is that it is equally harmful because it is realistic, that it may be mistaken for real, it may have reputational impacts. I may be misunderstanding this, but my sense is that is because it is realistic in nature. And that is the phrase that's used in the note to the provision, which talks about realistic fakes. So my comments in that sense are limited on that basis. If the assumption is that realistic fakes are harmful in a same or similar way to, if I may say, real images, then that should be made clear. They're treated as equivalent. They're given the same maximum penalty. Stepping back from that, there is other material falling short of realistic fakes. As you said, avatars, cartoons, or non-sexual material that may be terribly degrading, repugnant, that would not fall within this provision but may be harmful. There is an ongoing question that we need to have about, well, where does that sit? Currently, that could be, if it's menacing or harassing, then it can be placed under that type of provision or potentially stalking.
Yep.
But if it's offensive, then it would sit under section 474.17, for example. Whether that's appropriate, I think, is a broader question that I am supportive of having.
Excellent. Thank you. That's made it very clear in my mind. I might just ask Professor Flynn, did you have anything you wanted to add to Professor Clough's very useful explanation in that regard?
No, I think that makes a lot of sense. But I agree that there does need to be a conversation around imagery that sits outside of that, particularly as we start to see things like the use of virtual reality and the metaverse and factors like that, where we start to see these harms play out in other forms of context as well.
Okay, thank you. I want to move on to the issue of consent. And I think certainly, Professor Clough, I think you referred to the Victorian legislation, and you may well have, Professor Flynn. The Victorian, going to you first, Professor Clough, the Victorian legislation sets out in quite painstaking detail what constitutes consent and perhaps even more particularly what does not constitute consent. And it deals with the overarching principle that consent must be free and voluntary. It also provides that consent is not provided unless there's some positive action, which dovetails with the notion of affirmative consent. It also deals with the issue of intoxication. It also deals with the issue of coercion and threats, particularly in the context of a pattern of behaviour, whereas the bill we're looking at the moment doesn't go to that degree of particularity in terms of consent, what constitutes consent, and perhaps more importantly, what does not constitute consent. I'd be interested in your comments in that regard, and feel free to take it on notice if you'd like to give some reflection upon that issue once you've had an opportunity to compare the relevant sections in this bill compared to the legislation in Victoria.
I may take that opportunity, and perhaps I should just confirm my reading of the provision that it does not require proof of absence of consent. It requires the accused to either know or be reckless as to the absence of consent. But unless I'm missing a provision, which I may well be doing, I couldn't see it as an element of the offence to be proved that the transmission of the material is without consent. It moves straight from what the material is and the transmission to the first person knowing or being reckless, and in particular. So it's really, as I say, unless I've misunderstood that, it seemed to me potentially important that that be elevated as an element, given, again, the seriousness of the crime, that is really at the heart of this, that this is without consent. The Victorian provision places consent as a defence rather than as an element, so that would be another way of looking at it, making expressly the position that the person is acting, so placing it as a defence. I think I might take on notice the broader question. I think the advantage of enumerating in the way the Victorian provisions do, and that makes it consistent with other Victorian provisions, is making clear that positive aspect of consent, that this must be positively communicated. You can't simply assume, and that's a real danger in this space, that I just assumed everyone was sharing it, therefore I could share it. I think there is something very positive in making it clear that it must be positively communicated. But if I may take other aspects on notice. I'd like to think about that a bit more if possible.
No, that'd be very useful. Professor Flynn, do you have any comments or remarks in that regard? And again, feel free to take on notice.
Sure, thank you. I would say that I think when we're talking about I think clarity is always useful. So to be able to have a clear definition of what consent is and what it isn't, I think the Victorian legislation does do a positive job in making it very clear, as Professor Clow outlined, that you do have to get agreement, has to be positively communicated freely, voluntarily, etc. So I can see a benefit to doing this because I do think that it is useful. However, as Professor Clow also said, this is an element, not a defence. It's a different context, and I think that the idea that this bill accepts that consent is it means that it's just freely and voluntarily agreed, and that if you don't give any thought to that, you're still committing an offence, I think is a useful element of this legislation. And so that you should be thinking that you have to be getting consent before you're engaging in this activity. Having said that, I do think that there is importance in clarity to make sure that people can't therefore come up with reasons as to why the law didn't cover that aspect of consent.
Well, an example is the intoxication, right? So intoxication is dealt with, or being under the influence of a particular drug is dealt with squarely in the Victorian legislation. If you're intoxicated, if you're under the influence of a drug, you simply cannot give consent. So someone cannot say, well, I had an honest and reasonable mistake, they consented, I didn't realise they were intoxicated. It puts a greater burden upon you to actually obtain that affirmative consent.
I agree. And if I can say, and one other example from the Victorian legislation I think is positive is where they say that if someone had consented to you creating the image, for example, but not to share it beyond that, or to share it by email but not on social media, I think that clarification is useful. Correct.
Yep. Okay. If I can move on to the aggravated offences, and Professor Clough, you touched upon, I think in a reasonably positive way about, from your perspective, how the aggravated offence dovetails with the operations of the E-Safety Commissioner. We have heard some evidence earlier today that cast a question on whether or not I forget the use of the term, that 3 notices issued by the E-Safety Commissioner is perhaps too high a bar to trigger aggravation in the context of these offences. I'm interested in your views with respect to that.
Thank you, Deputy Chair. I don't have a particular view on that. My comment was really emphasising the fact that I think, as Professor Flynn has noted, non-criminal measures are very important in this space. It's very important to support education, but also civil penalties. It was really making the point that this legislation reinforces that civil penalty framework in this way, but I would defer to others and their expertise on the number that would be appropriate. I don't have a view on that, I'm sorry.
Okay. Professor Flynn, do you have a view on that, just to give you an opportunity?
Thank you. No, I'm much the same.
Okay, thank you. Can I ask a question about children? So we've received evidence from a number of stakeholders, including those who have statutory obligations with respect to protecting or advocating the rights of children, who've raised concerns about the criminalisation of conduct which might well be occurring or committed by children, and what the relevant consideration should be in that regard. And I note that the Victorian legislation, I'm not sure you're aware of this, but the Victorian legislation actually has a specific provision that says before a child under the age of 16 can be charged with the offences under the Victorian legislation, there has to be a signed direction from the Victorian Director of Public Prosecutions. So the most senior prosecutorial office in Victoria has to actually direct their mind to whether or not a criminal charge should be laid with respect to a child under the age of 16. Obviously, given your own research, you will be finely attuned to the issue of what's occurring in our high schools and schools and how children can fall into engaging in this sort of conduct and behaviour. I'm interested in your views with respect to getting the balance right in terms of having the criminal offences on the statute books, but also how they may interact with children. Professor Flynn?
Thank you. I agree. It's a very delicate balance. I lean towards the Victorian legislation. I think that when we're talking about, particularly with quite serious, quite severe penalties of up to 6 years or 7 years, that I think that there is a need to be getting approval or insight or just the expertise of the Director of Public Prosecutions before prosecuting a child for these types of offences. There's also the issue, of course, that when you are talking about children, if they're engaging this behaviour against other children as opposed to adults, which is this law is covering, then we're talking about a different type of offence. In a sense, we're talking about child exploitation material in that sense. So that needs to be treated in a different way when we're talking about the imagery that involves adults. So I would lean towards having this as something that from 16 and above that you should be getting approval from the Director of Public Prosecutions. I think that's working well in the Victorian context. I do think we need to be focusing on education and other forms of prevention when we're talking about children. And again, as I said, when we are talking about children committing these types of offences against other children, then we're running into a whole different minefield, if you like, where we need to think about what the implications for both the victim and the person who's engaging in these behaviours are.
Professor Clough?
I'd only add to that, which is really a question, as I don't know the answer to it, but certainly an issue is the role of sex offender registration, which we found with other provisions of young people engaging in material which contravenes child exploitation material offences, and whether those young people should be on sex offender registration. And similar issues may rise here. They may not, as has been identified, be creating images of children. They may be creating images of adults, but I'm presuming these are sexual offences. So I would have a question about whether there's a registration issue here and how we deal with young people in that regard, because that can have enormous consequences, obviously, for young people as well, if they're prosecuted and registered.
Okay. I've just got one final question, and Professor Flynn, I was listening very carefully to your introductory comments, and I think I tracked them pretty well in terms of understanding. But I'm afraid I'm not going to be your brightest student, because I fell over in the second one. You made a point which I had trouble following. Have you got that have you got that list in front of you, or did you just do it off the top of your head, which would be most impressive? But
no, well then it was off the top of my head. I might be able to recall.
Sorry. So it was the second point I think you're making about whether or not the image exists.
Whether or not the image exists. Oh, sorry. So it was around the threat offence. So that suggesting that if you were going to introduce some type of threat offence, that it should be irrelevant whether or not the offence whether or not the image has actually been created or whether it has been distributed. That the threat can exist whether or not the image does exist.
Got you. So the offence would be a threat to use a carrier service or whatever we refer to these things to disseminate an image. It shouldn't matter whether or not the image actually exists or not. It's the threat itself to use the carriage service. Is that correct?
Correct, because that's when it can be used in sort of domestic and family violence context, or even in sextortion context where it might be two strangers being involved.
Okay, your slower student has now caught up. Thank you.
Congratulations, high distinctions all round.
Thank you. First time ever.
I doubt that, Senator Scarr. I'm sure you're a HD student. Senator Waters, you have the call.
Thanks very much. Let's not compare marks. I want to thank both of the professors for the time you've given us today. Unfortunately, due to a series of absolute debacles, I didn't have the benefit of listening to your opening submissions, so please forgive me if the questions I ask are possibly repetitive. I will go back and read the Hansard when I've got a moment. But just a first question is a point of clarification. You've just referenced that the threat of the offence should itself be an offence, which I personally agree with. Can I just check, are you talking about the threat of the dissemination or the threat of the creation?
I would advocate for both, the threat of creating it and the threat of disseminating it, because I would advocate for introducing a creation offence, standalone offence, not just an aggravated offence. But either way, I think that it should be the threat to create and the threat to the threat to distribute.
Can you talk to us about whether there are any constitutional barriers to the feds doing that? The standalone offence of creation and then associated threat of creation?
So this might be something that Professor Clow needs to speak to a bit more than me, given the legal background. But my understanding is that the issue needs to be that it does have to link to a telecommunications.
Can't we find another head of power?
Possibly, but I would think, I don't know, I might defer to my colleague there to provide the legal expertise on that, but I can't see any reason why this shouldn't be, and I think it would be a really positive way to address these harmful behaviours. But I'll pass over to my colleague.
Yes, please, Professor Clough. Love to hear your views on, can we get around, if there's not any other head of power, is there any other way of circumventing that? And how can we have the feds, or is this something that the states will need to just collaborate on?
We're all handballing this. So I'm not a constitutional lawyer, but one of the advantages of the constitutional power in relation to a carriage service, from my point of view, is that it would actually limit the generation offence in terms of it would likely have to be generation with intent to distribute. There would have to be some specific intent attached to it rather than simple generation of the image. In terms of other heads of power, one possibility that I don't think exists that I think can be used, and I'm not a constitutional lawyer, is external affairs where you have international obligations. So there's a power obviously to...
Oh, maybe CEDAW.
Where you have an international obligation to enact laws, then that expands your jurisdiction in order to comply with that international obligation. But so that may be something to explore, whether there could be a power there or an obligation there. My concern about generation powers is that it becomes very close to a simple possession offence, that there is no other proof of an intention to do anything with it. Someone is creating an image, in the case of a deepfake, creating a fictional image. That's a very broad offence. We don't typically criminalise simple possession, that is with no further intention. We do with child abuse material, whether it's real or not, because of the nature of that material. I'm not saying there's no argument in that regard. I just think there needs to be a strong argument as to why creating something in your own home with no intention to do anything further with it is an offence. As Professor Flynn has noted, that is that is a state offence and has to be contrary to community standards, the creation of that material. I think that's all I would have to say on those points.
Okay, just want to tease that out a little more. And in my mind, the harm is still there, particularly if it's going to be used as a form of coercion in an existing DV situation. So, and we heard from survivors early today to that effect, and I certainly, agreed with that take. So, I wonder, and it's purely because I don't already know the answer. I wonder how the Victorian offence provision deals with that concept that you've mentioned of intention not to do anything further with it. Are you across that? Can you run me through that? Sorry if that makes no sense. I need more coffee.
I might take that on notice of. I may, or Professor Flynn may have a view on that, and I'm not unsympathetic to the argument. It becomes what we would call a remote harm argument, that even if you have it in your possession, there is a risk that it will be used further, either by yourself or others. There is a risk that that material will become disseminated, if that makes sense. And that is certainly an argument. The contrary argument, obviously, is it's particularly where it's a fake image, that it's a creation of an image. There is no proof. The question is, what is the additional risk? But I'll have to take on notice how the Victorian provision deals with that. I think it's said to be the creation is contrary to community standards. Was that right, Professor Flynn?
Yes, that's correct.
I think we're at early stages in working out what community standards would be around those images, but you may have a view on that, Professor Flynn.
Yeah, please jump in.
Yeah, I would just add that, yes, I believe that is how they get around that idea of that it is against community standards. Look, I believe that there are harms. I'm of a similar view that there are harms from the creation of this image, from someone creating an image like this of you, again, whether it's to use it for their own purposes or to use it for other types of purpose, whether that's coercion, controlling, extortion, or simply to use it for their own sexual gratification. So I think there are elements of harm that exist. So I would be pleased to see a standalone offence, but I agree that it would need some kind of element to it, such as the Victorian legislation, to allow it not to be, I guess, criminalising people's thoughts, as we have previously discussed, and just putting them on paper.
Thank you. Yeah, look, I might take that issue up of whether the Commonwealth could use a different head of power to create that standalone creation offence and then the associated threat of creation, because quite intrigued by the notion that various gender equality conventions, including the Convention on the Elimination of Discrimination Against Women, might potentially provide an avenue for the federal government to base the offence provision on that head of power. Obviously noting that would only apply where the material created against women, but noting that 90% of it is, according to one of our other submitters. Just briefly from me, because I think we're due to wrap up, could you talk to us about whether there is any other avenues that you think we should be pursuing to either stop the creation of this material in the first place or stop its promotion and dissemination in the context of the tech giants, deplatforming apps? Is there any other broader approach we should take or consider taking to address this really awful development in how to sexualise and victimise women?
I'm happy to jump in the first instance. I think that, yes, that there should be more resources in ensuring that the regulatory powers that the e-Safety Commissioner has to be able to be holding developers, websites, platforms, the tech giants, as you say, to account is important. I also think that there might be scope to look at regulation of advertisement around these types of tools on websites and platforms to make sure that they're not readily able to be accessible and advertised to people in that sense. But yeah, I do think that there is a need to be looking at I personally can't see any validation for having a tool available that allows you to nudify someone, to create a nude
nor
image
can
of
I.
someone.
Like,
So
how is that okay? Why can't we stop that?
Yeah, I would argue that there's no place for those to be advertised freely on our social media platforms or networks or websites. So I'd be looking at if there's ways for us to control the types of websites or things that can be made available or accessed in the Australian context would be useful.
And is that something the E-Safety Commissioner has powers to do already, or would that require additional regulatory powers for her, for that role to do?
In terms of advertising, I'm not familiar with whether they have any controls over regulation of that, but they do have regulations around harmful material or harassing or abusive material or sexualised material that they can ask for it to be taken down. I am not familiar with whether they have the power to be able to have taken down the tools or advertising or websites that might host this materials.
Okay, we might seek to ask the department about that if we don't have the E-Safety Commissioner to hand. All right, well, that's it from me. Thank you both very much.
Might just make a quick comment on that, just following up,
sure,
if I may. And I hasten to add that I'm not unsympathetic to the arguments about there being inherent harm in this. I'm really emphasising the need to justify it very clearly because it's a very broad offence. But certainly one way to approach this is to have an accessing offence as well as a transmission offence, that it's actually an offence to access material, and that would deal with your website situation. This is similar to child exploitation material. The argument is there is a market for this material. When you download it, you're creating the market. Therefore, we can criminalise, and that it's obviously within your jurisdictional power to do so. If you're looking at criminalising software, I'd encourage you to look at the cybercrime provisions of the criminal code, for example. The challenge here is dealing with software that is dual use. This material, this software does have appropriate uses. Obviously, it's being promoted in certain ways, but one of the ways to limit access or to criminalise access or criminalise more promoting is with reference to your underlying offence. So if generation is an offence or if generation is an aggravating factor, then this person is either in possession of it with intent to commit that or is promoting it with intent that someone use it to commit those federal offences. Does that make sense? So you link the possession or the promotion back to the federal offence, so that brings it within power, it's on a carriage service, and it helps to narrow something which is these are dual use. They can be used legitimately for other purposes. The question is how you narrow that down, and the cybercrime provisions deal with that for hacking type tools where it's an offence to distribute or promote them with an intention that they'll be used to commit offences under the criminal code. So thank you.
Yeah, thank you. That was incredibly helpful. And if you've got any further information about that particular aspect, the accessing of it, and in particular the promotion of it, and the fact that that could be hung off the existing regulatory head of power to enable the offence to be brought up, I'm really interested to read further about that. So if you've got anything pre-done, please send that through for the committee's consideration. Thanks both. Thank you, Chair.
Thanks very much, Senator Waters, and thank you to both of our witnesses for appearing today. That's all the questions we have for you. So the committee will suspend for the lunch break and return at 1:45 p.m. Thank you. Mr. Daniel Priespy, I think I'm saying that correctly, and Mr. Richie Hardcore, as well as representatives from Independent Schools Australia who are joining us in person. Thank you very much for being here today, and Universities Australia who are joining us via the video conference. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. This is obviously going to be a very helpful panel for us. We're really looking forward to asking you questions, but for the Hansard record, can you please state your full name and the capacity in which you appear today? And we'll start with you, Daniel.
Good afternoon, everyone. Thank you for the privilege. My name is Daniel Principe and I'm a youth advocate and educator.
Thanks very much. Richie?
Hi. Can you hear me okay?
Yeah, we can.
Okay, great. Hi, everyone. I am also an advocate, educator and public speaker.
Thank you very much. And from Independent Schools Australia, who are joining us in person, if you could have your name for the record and the capacity you're here today.
Thanks, Senator. Graham Catt. I'm the Chief Executive Officer of Independent Schools Australia. We're the peak body representing the independent sector of non-government schools. And so I'll let Tracy Taylor introduce herself.
Thank you. Hello, Senator. My name's Tracy Taylor, Director of Education Policy at Independent Schools Australia.
Yeah, wonderful. Thank you very much. And from Universities Australia?
Thank you, Chair. My name is Luke Sheehy. I'm the Chief Executive Officer of Universities Australia, the peak body representing Australia's 39 comprehensive universities.
Thank you so much for joining us today. Before we go to questions, of which we have many, I was wondering if anyone had an opening statement they'd like to make. We can start with you, Daniel or Richie, if anyone has an opening statement. Thanks, Daniel.
Thank you, Chair. The creation of image-based sexual abuse material is a tragic outworking of the increasingly digital world young people especially are navigating. Smartphones, social media, toxic influences, pornography, AI, and now deepfakes. I witnessed in my engagements with thousands of young people how these cultural forces shape their attitudes and social norms. Their perceptions of sex, consent, and relationships are influenced by these platforms, which embolden male sexual entitlement and the chance to bully and harm others. I hear these stories across postcodes. Harmful attitudes are encouraged and weaponized by this technology that makes these crimes not just possible, but simple. We must send a message that these abuses will not be tolerated. However, the law must come down, in my opinion, far more strongly against the creators of these programs, the app stores and ISPs who make these abuses possible. Until very recently, nudifying apps, as they're called, were accessible in the App Store and were rated for ages 4 and above. I want to note a recent case where teenage boys created AI-generated abuse images of classmates and were arrested. The victim's well-being and ongoing care demands the utmost concern of authorities and communities, and the young men need significant consequences. But let's pause and consider the online experiences for your average Year 9 boy. Exposed to pornography at least 2 years ago, having seen violent and degrading porn of women, exposed to deepfake ads on porn sites at least once a week, and have routinely seen sex bots and pop-ups in their social media and gaming spaces for the last few years, which encourage these AI tools, which then sends the implicit message to go and abuse their own female peers. This isn't to absolve individual responsibility and the urgent need to educate young people about online safety, consent, and the law. However, if we want safety by design to be a reality, then the onus must be on tech platforms to have the strictest protocols to prevent and remove the creation of this abusive material. These demands must be made to all culpable who ought to be met with severe consequences for non-compliance. An estimated 90% of all deepfakes are explicit, with the majority depicting women and girls. In less time it will take me to finish this statement, a realistic sexual image of you or I could be created through these platforms. These websites and apps should not be allowed to exist when they are created and utilised to abuse. They should not profit until they can prove they are safe by design and have implemented all measures to prevent these harmful crimes. This is why we also need our government to urgently implement age verification for pornographic websites. The ideas and attitudes from porn are shaping young people who are exposed, and the sites themselves are a primary gateway for promoting deepfakes and the AI tools themselves to then abuse other individuals. We must put the rights and well-being of women and children ahead of the profits of these industries. Thank you.
Thanks very much, Daniel. Richie, did you have an opening statement?
Yeah, it's really a rehash of my submission, but my submission was late, so...
Thank you. We read it and we're aware of your work, but if you want to give us a brief opening statement, then we can get to questions after that. So over to you.
Yeah, sure. Deepfake pornography has been aptly described as a new frontier of violence against women. Despite its relative infancy, deepfake sexual abuse material is already documented as being used to harass and attack people, primarily women and girls. Like any sexual act performed without consent, the creation of deepfake sexual material causes psychological pain and distress. It may be used to blackmail victims or used to extort sex acts from victims. Deepfakes may cause reputational damage, negatively impact victims' careers, friendships, and social networks. As we've seen with other forms of media harassment and cyberbullying, this combination of outcomes can lead to suicidal ideation and indeed suicide. Deepfake images and movies of unsuspecting victims may spread rapidly through social networks and are incredibly difficult to remove from the internet. Subsequently, there is an indelible element to the offending that may cause further and ongoing damage and distress to victim survivors. There are documented stories where deepfakes have been created that have been shared online alongside the names, addresses, and social media handles, a practice known as doxing. This further places victims at physical risk of stalking, rape, and assault. Working with both young people and offenders of domestic violence, I have countless anecdotes to share of individuals who have had nude photos or videos of them used to extort and blackmail them or shared non-consensually to cause harm. These acts are very real. Colloquially known as revenge porn, these images and videos may be created consensually, but then are used against a person, most often a woman, to intentionally cause them pain. Recent research shows that 1 in 7 adults have had someone threaten to share their intimate images. Further victims of sexual assault may have their rape recorded by perpetrators. These photos and videos can end up circulating on social networks or uploaded to pornographic websites, and the advent of deepfake technology exacerbates the use of technology to sexually victimize people, again, predominantly women and girls. Events do not even need to have happened for them to cause damage to someone's life. As technology has evolved rapidly, photographs and videos do not need to even be real to be distributed. Without deep cultural change, I see no reason why malicious actors will not use deepfake technology to continue this trend. The proposed criminal amendment provisions are part of the required cultural change we need. Criminal prosecution alone does not prevent offending. However, it is an important tool to leverage which demonstrates society's values and serve as a disincentive to some potential offenders and to give victim survivors the ability to pursue justice. As you're no doubt aware, when we discuss what causes gendered violence, it is the social attitudes about violence, sexism, and expectations of gendered norms of behaviour which play a role in creating an individual schema of core beliefs. Core beliefs are shaped in childhood by many things, and our digital media environment has quickly become a key source of ideas and values which people digest and internalise. While there may be an optimistic hope, the more that we can do as a society to provide a positive online environment for children and young people, the better the end result. By limiting the harmful content that we are exposed to and rejecting the idea that it is acceptable to dehumanize and degrade others by using technology, we can produce more positive long-term outcomes in our society. I support the proposed amendments as they serve as a deterrent, a consequent, and contribute towards creating a culture that clearly does not accept image-based abuse.
Thank you very much. That was great. And we'll go to Independent Schools Australia. Thank you.
Thanks, Chair. First of all, thanks to the committee for the opportunity to come today and to provide a submission. We did put a submission in, I think, last week. Probably just to touch on a couple of points. First, maybe who we are. So Independent Schools Australia, as I said, represents about 1,216 independent schools around Australia. There are currently about just under 720,000 students in those schools. Probably what we do try to stress is the diversity of those schools. Often the schools that feature in media coverage, and particularly sometimes in coverage of this issue, are larger schools, high-fee schools, but there's an enormous diversity of those independent schools. In terms of size, the majority of our schools are actually less than 500 students. The majority of those schools charge fees under about $5,500. So those schools and the staff that work in them, the students, represent a great diversity in terms of the resources they have available, the communities that they serve, the parents that send their children to those schools. I think the second point we'd like to make is that we contextualise this in the context of AI generally, and schools, teachers, parents and school communities are all grappling, I think, with AI and education in the broader context. What does this mean for our school? How do we deal with the ethics? And so deepfakes are part of that for a school community. It's one aspect of that challenge of how do we adapt and how do we deal with AI. And the rapid technological advances that are coming with AI make that particularly challenging for people to adapt and adjust to that. It creates significant risk and it causes significant harm. And just to re-emphasise what our other witnesses have said, for us, again, we support the proposal. I think has been pointed out that the criminal code and an offence that is clear is a very important part of the response, but not the total part of the response. So, very definitely the changes to the criminal code as a deterrent are absolutely critical, but along with that we need to make sure that there's education, so there is a widespread understanding that this is a criminal offence, that it does cause incredible harm, that there is more support for victims who actually are victims of deepfake abuse, and there's an understanding that this is a crime and this is a crime with victims, and that's part of that education campaign. And also, I think it's been mentioned before, criminal code in its own achieves some but there needs to be also more requirements for platforms, for social media, for websites, so that there is proactivity that we're actually preventing this as well, rather than just a code that's there to prosecute through the criminal code. And as I said, we've put in a submission. I'll leave it there. Thanks.
Thanks very much. Universities Australia.
Thank you very much, Chair. My name is Luke Sheehy, Chief Executive Officer of Universities Australia, and as I said before, we're the peak body representing Australia's 39 comprehensive universities. Can I acknowledge the traditional owners of the various lands we are gathered on today, pay my respects to elders past and present, and thank you to the committee for the opportunity to be here today. I want to make it clear at the outset that Universities Australia does not have the in-house legal expertise in this area and therefore is not in a position to comment specifically on the legislation this committee is considering. However, I will make some general remarks about the importance of this legislation and our in-principle support for new and emerging pieces of legislation and regulation to deal with the scourge of this issue. What I can say particularly is that our sector does not condone the sharing of sexually explicit material, including digitally created content, without consent. This is a damaging and deeply distressing form of abuse that no one should ever experience. Universities, along with parents, guardians, schools and workplaces, have a role to play in teaching right from wrong, and it is a responsibility we take seriously. Our members are deeply committed to fostering safe and respectful environments for all students, staff and campus users. In support of this commitment, many universities have established online learning modules to educate students and staff on respectful relationships and sexual consent. These courses are mandatory in many cases. Online modules work best when they are part of a broader prevention strategy. So universities offer in-person training, events and seminars to complement these resources. Universities also have policies on technology-facilitated abuse. Respect at Uni Week is another initiative our members participate in as a way of engaging with students and staff to explore what respect means and the role everyone can play in creating safer and more respectful communities. At a whole of sector level, Universities Australia has partnered with eSafety to combat online abuse and its impact on students and staff at universities. Our toolkit for universities aims to help university communities be safer online by building greater awareness of online safety risks, providing guidance on how to prevent, prepare for and respond to online safety incidences, and support student and staff wellbeing. The toolkit contains resources to help create university communities that are well informed about online safety risks, proactive about online safety measures, and prepared to implement best practice responses to online safety incidences. Universities Australia also has a long-standing partnership with Our Watch. Our organisations continue to work closely on initiatives aimed at preventing sexual harm in university settings. This includes developing toolkits and frameworks on primary prevention and hands-on work on our campuses to drive change. Additionally, we are working closely with the Department of Education on the design of the National Higher Education Code to prevent and respond to gender-based violence. And of course, I'm happy to take any further questions from the committee. Thank you.
Thank you very much. I'm going to start off questions. I think given the time we have, we'll all have to just choose our priority questions to put to you, but even though I'm sure we have lots to ask you about. I wanted to ask Daniel and Richie from a starting point, is the work that you're doing or seeing with is it across working with young people, young men, young women? What's that background so I know how to couch these questions to you?
May I?
Yeah, both of you, one after the other, sorry.
Yeah, I work with co-ed audience as well as all boys audiences. And I also work with adults as well, like men in rehabilitative spaces.
Yep. Great, thanks, Daniel.
Likewise, tens of thousands of young people, predominantly boys, but co-ed young people of all backgrounds, and from year 5 all the way up to university, as well as caregivers, educators, health professionals.
Well, perfect. You will know the answer to these questions then. I am really interested in, look, the committee's job is to consider this bill and the legislation put before us, and to think about ways we could improve it, or things that it might overlook. But at a very basic level, I really want to go back to what you've both said in your opening statements about the importance of criminalising this behaviour, because at the moment it's not criminalised at all. There are crimes that cover revenge porn, but where we've got this situation where it's a fake image, our laws haven't been designed to deal with that. And so when you're speaking to young people particularly, what is the importance of setting the standard through this criminalisation? Do you think that will be, I'm sure there's a lot of work we need to do through education, and I'll come to that in my second question, but in terms of a starting point, setting the standard through criminalising this behaviour, how important is that to shift the cultural conversation that we're having with young people? I'll go to you first, Daniel, and then we'll go to Richie.
I think Richie said it well, and I'll rehash in the sense of what becomes normative. Young people are just guided by what is common to them. Like, I wasn't speaking to young people about sextortion and dick pics 8 years ago, but sadly, and forgive me for stating that, like, we have to talk to them about these topics now. And just the same, this all becomes normative, what we allow, and I do hold to the view that laws can be educative, while certainly not the full solution. And so I think there is a huge lack of understanding for young people. And from my understanding, reading submissions and a lot of the research that's gone into this, it creates such a vulnerability for the victims of image-based abuse, because they don't realise the scale of the harm done to them. They're experiencing it, but I think 71% of them never spoke up about it or sought to report it, from one of the research that I saw. And so I think there's a huge part, not just for the perpetrators, but the victims, to know that us as a society, that our laws are actually going to support them.
Yeah, thank you. And Richie, what's your take on that?
Yeah, I support what Daniel said, but I think it's really important that both potential offenders know that what they're doing causes harm and damage. I think so much of our young people's socialisation is through devices now, that they forget, due to the online disinhibition effect, that there are real people at the other end of their actions and their behaviours, and that the images, the words, the videos that they may be creating, however ethereal they might think they are because of its digital nature, actually leads to deep, deep psychological harm for a victim. And that psychological harm a victim needs a place to be able to take that, to develop some sort of sense of closure or justice for the very, I hate the argument that words are violence, but it is a violent act to create a deepfake pornographic image of someone. And in my work, I've met young women who have often been vulnerable and have been trafficked or coerced into creating pornographic movies, and even removing that movie doesn't get rid of that documented act, because often they'll be downloaded and reshared through different social networks and re-uploaded. And the same, I truly believe, will happen with deepfakes. And we need to be able to use the law as part of a broader package of solutions.
Yep. Thank you. And it must be really difficult, though, for young people when you're talking about what they see as normative, and we'll talk to the eSafety Commissioner about this, but when there's an app that's available online, promoted, that gives you access, I think it's Nudify is what it's called, that gives you access to this type of technology, it would be really hard for young people, I imagine, to see the difference between what is criminal and what isn't, if that's the type of access they're getting to technology. What part of education do you want to see play a role in this? And I'll open it up to our other guests as well, because I think they'll have something to add. But starting with you, Daniel and Richie, to begin with, this bill seeks to criminalise this behaviour. We're very open to making further recommendations. What sort of educational program do you think would be helpful leading on from criminalisation? Is it about just the crime and what it is, or is it a broader, where this crime fits into a broader conversation around sexual violence and gendered violence particularly? I can see nodding, so we'll put that. Thanks.
I think it's not just about the legality of it, because everyone who commits a crime doesn't pause and think necessarily about the logical outcome of their behaviour and how it might lead them to, incarceration. There is an emotive element, an impulsive element, particularly for young people whose brains are underdeveloped, who don't, neurologically mature until their mid-20s, who are also steeped in a culture, as Daniel mentioned, that is inherently sexist, not inherently, but currently sexist, hypersexualized through mainstream entertainment, through pornography, through TikTok, through YouTube. So the blurring of lines towards creating that material themselves really needs to be fleshed out and explained. And I don't think it's just about you will get in trouble if you do this. How do we put empathy at the forefront of that education? Because I truly believe that it's not what we tell people in graphs and charts that lead to behavior change. It's how do we make them feel? How do we help them understand that if you're putting your classmates, I don't know, I feel upset myself talking about it. If you're putting your young classmates' face over a pornographic, movie stars, video, or whatever it may be, like that can really, really destroy a person, like internally. So how do we, in ages and stages ways, ensure that our young people, boys and girls, because no doubt young men have been victims and will be victims of deepfake pornography too, that there are real consequences for your actions, and yes, you'll be held accountable for them, but at a preventative lens, why do you want to do this? Yeah. So I think that's a really important component to it.
Thanks.
I'll just pick up on that very quickly, if I may, because I don't want to add too much to it. I so agree. Yeah. And I am obviously an educator and I am a consent ambassador for the government, which I'm grateful for. However, as I say at the end of all my talks to the young people, I don't need to write on a board to a group of young, empathetic, kind young men, don't sexually assault an unconscious woman. Don't make jokes about rape, right? Because yes, I think we have to educate and I want to educate, but Richie's touched on it. It is the empathy piece, and that's why I share so many stories and I ask young people to not just give me the right facts or answers, but I ask them, how would this make someone feel? What would that be like to rock up to school if? How would you feel talking about this with your... Because I actually want to engage their hearts, and call me a chronic idealist, I am, but that's what I seek to do beyond just the laws. But of course, we need the laws, and forgive me, Chair, if we will touch on it. I think that's why I also want to advocate for the consequences for the adults creating these platforms that do harm children, because even the boys who do act out in this way, they are first groomed before they then groom or harm others. So I'll just mention that and I'll park it now.
Oh no, thank you for adding that. I think that might come up in other questions. I'll just hand over to our two education witnesses to add to anything to that, and then I'll hand over the call if you wanted to add anything.
Yeah,
Mr.
thanks.
Gatt.
Yeah, look, I completely agree. I think starting with from an educator's point of view, the fact that there is such ease of access to a platform which actually allows you to create this when you're dealing with young minds and people in their formative stages is incredibly difficult to deal with. And I agree as well. I think what we hear from educators is, yes, it is helpful to point to the law and say, look, this is illegal. That's part of that education campaign because that resonates with people. But I think from an education point of view, this is we've described in our submission, it's an incredibly extreme form of bullying facilitated by technology. And therefore, when we think about bullying and the best way to educate and how that's done and has been done effectively, as we're saying. It's through empathy, it's through helping them understand that this has an impact which isn't you run a risk of being prosecuted. The impact has to be understanding the impact that that has on another young person, has on a classmate, and trying to get that across. So I think when we talk about education, yes, understanding that you've done something illegal is part of that. I think understanding from a school point of view, this is one of those challenging things as well, that what schools increasingly deal with is what is inside the school gate and what is outside the school gate, and where does your responsibility start and finish. And again, I think what the feedback from educators is, and Tracy might pip in, is basically this is a societal problem that we're trying to educate our children about, and that's the education piece that needs to sit alongside criminality. So yes, you can be prosecuted for this, but actually this is going on around us. This actually guides people's behaviours and people's thinking. This is the impact it has on people like you, and the education about preventing that. Prevention is so important. Prosecution is what we need to be doing people where we've failed to prevent the behaviour. I think every educator would say everything we can do to prevent it happening in the first place would be our goal.
Thank you. And Mr. Shealy, maybe in your answer, if you don't mind touching on the relationship you've got with Our Watch as well in the short time that we have. So
yeah, absolutely, and thank you very much, Chair. Look, I think it's really it's really a good thing that we're seeing two young men talk about this in the context of this hearing, and thank you both of you, Richie and Daniel, for what you're doing. Societal problems don't begin and end at universities, but we have a unique point of view as universities as places of knowledge, curiosity, to develop citizenship, and in a healthy democracy, we have a role to play. So I don't shy away from that as Chief Executive of Universities Australia. Certainly, we learn the lessons from the past. There's a unique, obvious opportunity at a university to grow as an adult, but also to behave badly as an adult on campus. So we are striving to make our campuses better and safer places for all those involved, both students, staff and visitors alike. They can be intense places, as many of us have seen in recent years, particularly due to other tensions that coexist. And so we want to make sure that everyone comes on campus has the opportunity to express themselves, but also has the opportunity to be safe. And so we work obviously on consent and other frameworks to support our student cohort. What I would also say before I touch on Our Watch very briefly, Chair, is that university contexts have emerged as different places as well. So it's not just an 18-year-old or a 17-year-old finishing school coming onto a university campus and potentially staying at a university college, like it may have been a century ago. What a university experience is increasingly for people right throughout their working lives, going to a university to get the skills they need to get on with their life of work and have a meaningful career. That means universities, students come from all walks of life and all different ages and perspectives. And increasingly, more and more students are engaging with university study online, both in multimodal context and also, of course, fully online through online delivery. So the context in which we're responding to these trends in society are becoming increasingly complex. And you add in all of the factors like AI and all the other things that are disrupting that. Universities are having to respond, and sometimes we're having to catch up, but certainly we have eminently sensible and clever people on our campus that help support that. I'll just touch briefly, if I can, on Our Watch. I took over the Chief Executive role here at Universities Australia in February. I've been in this sector for 22 years. I'm very familiar with the excellent work that Our Watch has done. We couldn't do half of the things we do without the collaboration across the sector, be it practitioners, activists or student groups. We aim to listen. We don't always get it right, but we aim to listen in order to build effective toolkits, effective approaches, and certainly measures like the National Student Safety Survey, which we'll be undertaking in the period ahead, and we'll consult with Our Watch and other key stakeholders in how we develop that. We're committed to delivering it. It's certainly part of the proposed code to address gender-based violence that the government's proposing, and we'll work closely with those practitioners that understand how to deal with the scourge of gender-based violence on our campuses, and to design a survey that is fit for purpose to help us understand the incidences of gender-based violence both on and off campuses or within the university context. And I think that's an important thing for Australia, and we're committed to doing it.
Thank you, Mr. Chair. I'm going to about to hand over the call, but you would be unsurprised to know that committee members from this committee are very pleased to hear you say that and acknowledge the hard work of members of this committee to work with you and your organisation on progressing that national survey. We're really pleased to hear that you're committed to it, and I think it's an important thing that needs to happen for our country and for every university student. So thank you for that commitment today. Senator Scarr, you have the call.
Thank you, Chair, and I'll just associate myself strongly with those remarks from our Chair. Mr Sheehy, can I thank you for your appearance today and thank you for your submission, greatly appreciated. I just wanted to tease out, if I could, the last paragraph of your submission, if you've got it there. I'll just read it for the Hansard record. You talked about the extensive work the sector undertakes to educate students on the importance of consent and in fostering safe and respectful relationships, end quote. The question I have is just in relation to this issue of consent. Does the work which you undertake, and feel free to take this on notice, does it encompass the intricacies of giving and obtaining consent in the context of images which may be transmitted over the web, over the internet, through mobile phones, etc.?
Thank you, Senator. It's a very good question. I think, like all emerging technological disruptions, our good practice and the way that we implement that across the campus evolves over time. So I'll take on notice the specifics to how each of those individual measures. What I will say is there's a raft of approaches. Every university campus, as I said before, is not the same, right? Some are large, complex, inner city campuses, some are regional, some are online. So the approach is unique to the cohort, and we develop individual approaches at each institution. But what I'll certainly do is take on notice the more the specifics to that question that you've asked around the technology and sharing of images.
Okay, thank you very much. If I could go to Daniel and Richie, just in relation to this issue of consent, and I'm not sure if to what extent you've had a look at the provisions of the bill, but there's a bit of a difference in approach between the Commonwealth Bill, which takes a sort of a higher level view with respect to consent, and say the Victorian legislation that goes into the detail of what constitutes consent and perhaps more particularly what doesn't constitute consent. So, for example, in the Victorian legislation, it's clear that a person does not consent if the person does not say or do anything to indicate consent. So there's this concept of affirmative consent. So unless someone does something positively to indicate consent through an action or through saying something, they can't be taken to have consented. And then there is, as you go through the provisions in the Victorian legislation, it cascades through a series of scenarios and examples where, for example, if someone consents because they are fearful of force or harm, that doesn't represent consent. If someone's the subject of coercion or intimidation, that doesn't constitute consent. If someone's intoxicated or impacted by drugs, that doesn't constitute consent. How important do you think it is for legislation of this type to actually go through those particulars with respect to consent and make it clear as to what does constitute consent, and perhaps more particularly what the circumstances in which consent simply cannot be given because of intoxication, etc.? If I can go to Daniel first.
Thank you, Senator. I agree. I think obviously consent needs to be clear. The government has obviously updated our definition of consent that we use to teach sex and consent and respectful relationships across the nation. So in my mind, that would, I think, extend to all legislation and I guess all policy looking at, well, what is consent? I think for me, even as a consent ambassador, I'm always wary, as you've highlighted, of the ways that consent can be coerced and power dynamics, and also just ignorance, especially for young people, can limit how much they understand what it is they are consenting to, whether it be a sex act or the distribution of sexually explicit images made of themselves or into cartoon AI replicas. And so I think for me, I'm always a bit wary around the language of consent, especially in the realm of young people whose full understandings, even if they're not intoxicated and they've said yes, and they clearly have, I still am cautious when we're then talking about 12, 13, 14, even say a 16-year-old who may be legally able to consent. What have they consented to, and do they really understand the scale of consequence to themselves and others? So I always keep that in mind. I'm not sure if that's helpful though.
No, that's very helpful. And just before I go to Richie, I guess one of the reasons why the full ramifications of what especially a young person is consenting to needs to be carefully considered is because, or one reason is it's so difficult to remove these images once they're publicly available, and young people may not be aware of the danger in terms of these images continuing to be available on the internet. Is that correct?
That's right. That's exactly right. Yep.
Okay. If I can go to you, Richie, your comments in relation to that, this issue of consent and how particular we should be in terms of considering the bill to define what consent means, or more particularly when there isn't consent.
Yeah, thank you, Senator. Yeah, I agree with what Daniel said and what you've outlined, that you do need to explicitly demonstrate what consent is and isn't, and the broader context in which it is, being obtained or not. And it's not simply just a yes or no, do you want to do this or can I do this? There are a whole range of contextual factors that Daniel's already mentioned, such as age, positions of power, intoxication, mental ability. We know that our people who are disabled have higher rates of sexual victimization. So I think being incredibly explicit, spelling it out, and also how do you transmit that information in a way that young people understand and lands with them is going to be incredibly important.
Okay, I've just got one last question because I know the Chair will be keen to share the call. Question to our friends from independent schools. I note in the submission you refer to students accessing AI software to alter images of staff and/or students, and students accessing AI to alter staff speaking within a school context, replacing their speech with inappropriate sexualised or racist language. So this is an issue that's impacting both students and potentially staff as well. Is that correct?
Yes, that's correct.
If you could just speak up a little.
Yes, certainly. That is correct. The way that the apps are changing so rapidly, it's very easy for them to then manipulate someone else's speaking, and even the technology is coming to a point where they could even have the video of that person speaking, not just the language itself. So in terms of what you were just saying before, Senator, about the consent and how explicit the wording should be in the bill, while I don't have a legal background, I think anything that can future-proof as much as possible the rapid evolution of technology, so that in 6 months' time you're not coming back trying to reword a bill, because trying to keep up with this rapid technological advancement is something that affects everyone in society. And I think it won't just be deepfake sexual imagery, but deepfakes, it's already happening with political views and things like that. Yep. So it's a huge issue for all of society.
Thanks, Ms Taylor. Thank you, Chair.
Thanks. Senator Waters, you have the call. Sorry, we haven't left you too much time, but I'm sure you can squeeze them in.
Thanks, Chair. Richie and Daniel, I just wanted to thank you so very much for the work you do. You spoke so powerfully, and it's really very heartening as someone who cares deeply about these issues, as I'm sure many of us do. It's really lovely when you hear such positive masculinity being expressed and the values that I believe our young people should be learning about. So thank you so much for doing that in a way that hopefully they will hear it, and you'll speak to them at a level that will land with them. You made a really interesting remark, which I liked, about empathy, but yeah, I can't remember if it was Richie or you, Daniel, that said you want people to understand why do they want to do this. And I'm interested from a psychological perspective, what have you learned in all of the teaching that you do with kids or adults, but predominantly with kids? What have you learned about why it is that people want to do this? What's the thinking that prompts someone to even think about doing this? And how do we change that thinking?
Oh, man.
No, that's a big question. I'm sorry, but if you can give us a snapshot.
Well, you go. Do you want to go first, Daniel?
Yeah, I'm happy to. Obviously, norms influence what we do or don't do. For example, to bring an example that I think is very relevant and current, is sexual strangulation right now. It wasn't normative 10 years ago. It has become increasingly normative. Huge risks for women especially, who are often receiving this. And so why has that happened? Well, culture. And when I talk about porn culture, I don't mean just watching pornography, but the ideas, the jokes, the memes, the things expressed on Netflix shows that reinforce this idea that we should strangle and seek to strangle. And that is, that is something that is sought after. And we can debate that. But in this instance, it's the same. I've seen someone else do it. That was funny. And it usually starts with schools tell me, not necessarily sexual, but definitely depicting somebody through AI in an inappropriate or degrading way that's not necessarily sexualized, and that may get a laugh. So there is this peer affirmation, whether we want to call this toxic affirmation, especially for boys to get cred, there is that. I think there is a sense, and a growing sense, and in my workshops I ask boys explicitly, do you feel that there is a push to get back at women and put them in their place? And they tell me yes, they do, because I'm not asking them to fess up to that. I'm saying culturally, do you see that as a trend? And they say yes. And we talk about that from kitchen jokes and make me a sandwich jokes all the way to pornography and image-based abuse. That they acknowledge that. And so there is this rise, and this is where there is signs for hope, is I think young men are increasingly able to critique their culture. It's how do we help them to I guess, abstain from it or resist it and not pay a high price for being an upstander and having empathy. I think these platforms and the research that I've seen and engaged with is both the mediums themselves and the message that we encounter do reinforce a callousness. And I think within pre-existing kind of hegemonic ideas of masculinity, it reinforces this callousness, this I'm unaffected by what's happening to this other. And this is just another tool and device, as I mentioned in my opening statement, to embolden and weaponize that's already there. So I think it's all of that. And of course, you know me, I'm going to talk about how pornography does, reinforce and drive these appetites as a significant conditioning tool for boys especially who experience this well before their first kiss and sexual experience and creates a very, toxic sexual script in a lot of instances.
Thank you. Over to you, Richie.
Yeah, just to build on that, I agree with Daniel and the cultural element to it. And we're exposed to these normative ideas from a really young age. Like I have two sons, one's 2 years old, one's 10. And I remember when my 10-year-old came home from daycare, very upset that the boys didn't want to play with him because he wanted to play with Care Bears that day for whatever reason, and that's what girls did. We have like a really gendered norm. Yeah, and we have like a really gendered normative script that children impose on one another because of what they're consuming from the adults around them, and that plays out in culture. And depending on the socioeconomics of any given family or community, you have all these different influences. Whether it's the high-powered Wall Street, Wolf of Wall Street stereotype, or the working class tradie who's wolf whistling at a woman as she walks by, right? And so our boys take cues from that. And we have to know that many boys don't have good male role models, and when they don't have good male role models, they're raised by media environments and by their peers, and social media and digital technology is a big part of that now. And I think broadly, I think our young men are getting kind of caught up in this political culture war that has really taken a lot of the Western world over the last 10 to 20 years. And for better or worse, many of them do feel excluded as society radically changes, and they do feel embittered and it's not to excuse their behaviour, but to understand it in order to address it. We need to think, why is someone like Andrew Tate one of the most popular social media figures of 2022, 2023, despite criminal charges for rape and human trafficking?
Yeah.
And while he might have fallen out of favour, we have this new rise of neo-masculinist ideas being presented by Twitch streamers and YouTubers, and young men gravitate towards that, and that leads to things like using deepfake technology to humiliate and hurt your female peers. So how do we give, I think, our boys, how do we call our boys in, I think is really important, right? I think in the Me Too era, we did a good job of calling out bad behavior and pointing out what harassment and assault and violence is. How do we take that a step further to a preventative lens, a preventative angle, and give them a critical media literacy? Because as Daniel said, it's not just porn or deep fake. You listen to top 50 charting songs on YouTube, and they're singing about choking people, men and women, right? Like, and that's presented as Daniel said, really normative and cool. And to question that, like you're not cool anymore. Like, you pay a social price for critiquing popular culture, and you get pigeonholed as like conservative or Christian or whatever it may be, rather than I'm just not down with like potentially strangling someone for my sexual gratification. Does that make me uncool? So be it, right? And yeah, so how do we help our, I don't know, it goes back to my opening statement, I guess. How do we make empathy, kindness, connection
cool again?
Cool again, man. Like, make kindness cool again. Like maybe that can be your campaign slogan. I don't know.
I love that. I've been wanting to say that for about 10 minutes, and you just said it, which makes me even happier.
Senator Waters, I'm really sorry, Senator Waters, I don't want to cut you off. I just want to, we've got the E-Safety Commissioner due next.
Could I just put some questions on notice? Would that be all right, Chair?
Of course, I'm sure the witnesses would be happy.
Can I say them now? Yeah, great.
Yeah.
That was incredible. Thank you both. Please keep up doing that wonderful work. A quick question for Unis Australia. What's the pipeline that you'll use to inform students of this new law once it passes? And secondary question, thanks for the survey, but please make sure that 17-year-olds on campus can be captured, because that came up in one of our previous hearings. I know you've got issues about whether you need parental consent, but it's important that everyone's experience on campus is captured. Question to the independent schools, same thing. How are you planning to make sure that there's an educative piece so that students know about these new rules? And question maybe more for the department, will this be part of the respectful relationships program that's in the curriculum? And maybe Richie and Daniel, if you could take on notice, I liked your suggestion about targeting the app stores and the tech grants and the tech giants. And so I'm interested in whether you've got anything further to say about the legitimacy that having these apps available gives when we're trying to tell kids that it's not legitimate and it's criminal, and the sort of the disjunct there in the messaging. And anything further that you want to say about the ratings? I think one of you made a comment about one of these ridiculous apps was rated as appropriate for 4-year-olds and up, which blew my mind. We'll ask the Safety Commissioner about that in just a minute. I think they were all of my questions. Thanks very much, everyone.
Thank you. We will have to get the answers to that on notice. I think some of them may have been statements, but the ones that are questions, we'll get them on notice. I know, Senator Waters. You've put Universities Australia on notice. Thank you very much. But we'll get those questions back at another time. I'm sorry, we've just run out of time to ask any more questions, but thank you very much for appearing today. Thank you for all the work that you do and your insights into this really deeply troubling problem. And hopefully we can get this law passed and we can continue your good work. Thank you very much. That's all the time we have for those witnesses. I now welcome Ms. Julie Grant, the eSafety Commissioner, who's joining us via video conference today.
Thank you very much for having me. I also just want to introduce my Head of Legal and Policy, Alana Harper, who may be answering some questions.
Okay, wonderful. Just before we go to that, information on parliamentary privilege and protection of witnesses and evidence has been provided to you and is available from the Secretariat. I do need to just put on the record that I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy, shall be given reasonable opportunity to refer questions asked to an officer or superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, I think you may have already done this, Commissioner, but can you please state your full name and the capacity in which you appear today?
Sure. Julie Inman Grant, eSafety Commissioner.
Thank you. And Ms. Harper?
Alana Harper. I'm the Acting Manager of the Regulatory Policy and Strategy team at eSafety.
Thank you very much for joining us today. We have an opening statement that's been given to us. Commissioner, I just thank you for your submission and for your opening statement. I just want to flag with you from the outset, we don't have a lot of time today. So I'm going to hand over to you in terms of your opening statement. There is so much content in there that is really helpful for the committee. There's also a lot of questions that we have for you as well. So I'll just ask you to be a bit mindful of that with the brief opening statement. Thank you.
Why don't I do about 2/3?
Yeah, it's a very difficult balance, I understand. And a lot of it, I've read the opening statement, some of it deals with context outside of the bill itself. We're obviously keen to hear your views on the bill, and we'll be able to ask you some questions, I think maybe on the broader issues, but they're all relevant and important. So over to you, Commissioner.
Right, I think you're right. We're talking about an ecosystem approach here.
Yeah.
And we see a lot of the harms interlocking. So while we may consider them as civil or criminal or as image-based abuse or child sexual abuse material or sexual extortion, we're again seeing a melding coming into our offices. But I want to thank you for the opportunity to address the committee. I come to you from the land and waters of the Gadigal people of the Eora Nation. I'd like to pay my respects to their elders, past, present, and emerging. Clearly, there's some compelling and concerning data that explicit deepfakes have increased on the internet by as much as 550% year on year since 2019. It's also a bit shocking to note that pornographic videos make up 98% of the deepfake material currently online, and 99% of that imagery is of women and girls. So let me start by saying that deepfake image-based abuse is not only becoming more prevalent, but it is also very gendered and incredibly distressing to the victim survivor. To supplement eSafety's submission, I'd briefly like to describe two areas of deepfake abuse I'm particularly concerned about. These are the perpetuation of deepfaked image-based abuse, and we're not calling it deepfaked porn for the same reason we don't call it revenge porn or kiddie porn. We don't want to trivialize or undermine. This is not porn for the pure interest. We want to focus on the abuse. So in this case, deepfaked image-based abuse, but also the creation of synthetic child sexual abuse material. And while I'm aware that CSAM is covered elsewhere under the criminal code, the issues are inextricable and germane to this broader conversation. And as I mentioned, the melding of harms types we're seeing coming into our investigative division. I also just want to state up front that we support the deepfake legislation at the heart of today's hearing. Criminalization of these actions is entirely appropriate, serving as an important deterrent function while expressing our collective moral repugnance to this kind of conduct. And I believe that the bill adds powerfully to the existing interlocking civil powers and proactive safety by design interventions championed by eSafety, but also contained in some of our systems and process powers. And through these, we should feel justified putting the burden on AI companies themselves to engineer out potential misuse. To demonstrate, here's a description of a popular open source AI nudifying app. Nudify any girl with the power of AI. Just choose a body type and get a result in a few seconds. And another. Undress anyone instantly. Just upload a photo and Undress AI will remove the clothes within seconds. We are the best deep nude service. So it's really difficult to conceive of a purpose for these apps outside of the nefarious. Some might wonder why apps like this are allowed to exist at all, given their primary purpose is to sexualize, humiliate, demoralize, denigrate, and create child sexual abuse material of girls, according to the predator's personal predilection. A Bellingcat investigation found that many such apps are part of a complex network of nudifying apps owned by the same holding company that effectively disguises detection of the primary purpose of these apps in order to evade enforcement action. Shockingly, thousands of open source AI apps like these have proliferated online and are often free and easy to use by anyone with a smartphone. So these apps make it simple and cost-free for the perpetrator, while the cost to the target is one of lingering and incalculable devastation. So I'm pleased to say that the mandatory standards we've tabled in Parliament are an important regulatory step to ensuring proper safeguards to prevent child exploitation are embedded into high-risk, consumer-facing open source AI apps like these. The onus will fall on AI companies to do more to reduce the risk of that their platforms can be used to generate highly damaging content, such as the synthetic child sexual abuse material and deepfaked image-based abuse involving under 18s. And these robust safety standards will also apply to the platform libraries that host and distribute these apps. You can kind of think of them like the app stores for open source AI apps. So these companies must have terms of service that are robustly enforced and clear reporting mechanisms to ensure that the apps they are hosting are not being weaponized to abuse, humiliate, and denigrate children. eSafety is also concerned that these apps are using sophisticated monetization tactics and are increasingly being found on mainstream social media platforms, boosting their visibility and availability, particularly to younger audiences. Now, a recent report by the research firm Graphica found that there was a 2,408% increase in referral links to non-consensual pornographic deepfake sites across Reddit and X in 2023 alone. We're also concerned about the impacts of multimodal forms of generative AI. For example, creating hyper-realistic synthetic child sexual abuse material via text prompt to video, as well as highly accurate voice cloning and manipulative chatbots that could supercharge grooming, sextortion, and other forms of sexual exploitation of young people at scale. Now, I'm conscious about the time, so I will probably leave it there. But what I also wanted to mention is that we're part of a global network of in-hope hotlines, and I think it's worth noting that deepfake detection tools are lagging significantly behind the freely available tools being created to perpetuate deepfakes. And these are becoming so realistic that they're difficult to discern from the naked eye. And rarely are these images accompanied by content identification or provenance watermarks to help detect when material is AI generated. The second is that we're already receiving reports of synthetic child sexual abuse material, deepfaked image-based abuse, and deepfakes for bullying purposes against children. But in order for material like this to be hashed or fingerprinted by an organization like ours or the US-based NCMEC, the National Center for Missing and Exploited Children, it must be first notified by law enforcement or the public. This material can be produced and shared faster than it can be reported, triaged, and analyzed. And the fact is that synthetic CSAM is already challenging the global system of digital hatch matching that we've worked so hard to build over the past 2 decades. And this AI-generated material is starting to overwhelm both investigators and hotlines. NCMEC told us that they received only 5 reports from open source companies in the US about reports of AI-generated material. That is 5 out of an estimated 15,000 US-based AI companies in 2023. Instead, 70% of the reports of AI-generated content to NCMEC were made by social media platforms that have been used to distribute the material. And I would just wanted to say here, we now have social media site search engines codes of practice in place, and we will be starting to look in terms of compliance measures there. But there's so much more we need to do around education. This is, is an area I've worked in for 7.5 years. We know it takes a long time to get parents across the issues that might be confronting them and their children. I don't think parents are prepared for what deepfake abuse may wrought on their children. So we're ramping up our efforts around that area and also around sexual extortion, which we've seen troubling of reports into our office around this past year.
Thank you. Thanks very much. And thank you for the abridged version. I'm just conscious we've got so many questions for you about this area of work that you're undertaking. I'll just kick off with questions, if you don't mind. Have you had a chance to see some of the witnesses today and some of the evidence, or get a bit of an idea of some of the issues that have been raised?
I've been pretty back-to-back.
That's okay. I can understand that. Can you outline for the committee what powers you have under the Online Safety Act at the moment to address deepfakes and other types of online abuse, and how will those powers interact with the criminal offences that are being proposed?
Right. Well, as you would understand, this is largely a takedown scheme. And the simple fact of the matter is that most people who come to us, often after they've been to law enforcement, just want the intimate imagery taken down. So, and we of course consider image-based abuse a form of violence. So what our image-based abuse scheme currently handles are the creation of intimate images without consent, the sharing or distribution of intimate images without consent, or threats to share or distribute intimate images without consent. And because we did a lot of horizon scanning work in around the 2020 timeframe, we did our first tech trends brief on deepfakes in 2020 and couldn't get anyone in the mainstream media to pick it up. But we were conscious that we were watching a train crash in slow motion. So during the planning and inputs around the Online Safety Act of 2021, we made sure that synthetic material and deepfakes were covered through all 4 of our complaint schemes. So that includes all of our online content scheme that deals with child sexual abuse and pro-terror content, image-based abuse, adult cyber abuse, and youth-based cyberbullying. And we've now received deepfake reports into every scheme with the exception of the adult cyber abuse scheme. I can talk to you a little bit if you're interested about...
Oh, no, I have more questions. Sorry, Commissioner, but that's perfect. Thank you. I think the second part of my question, it might be helpful to expand on that. It was about... this bill seeks to bring in these criminal offences, particularly an aggravated offence where you issue a notice and it's essentially ignored. You've had to issue 3 notices. So how do you see these criminal offences working with the powers that you have? I think there's 2 parts to that. How do you see them working in setting a standard of what the community expects from behaviour and for victims understanding what criminal behaviour is and what it looks like? And then how do you see it working on a practical level with the aggravated offences that will sort of will jump off the work that you're doing?
Right. Well, again, as I said, we welcome this. We welcome other tools in the toolkit. I should start by saying we do have a 90% success rate in terms of getting image-based content down from almost exclusively overseas domiciled sites. And we've also used a range of our remedial powers, including 10 formal warnings, 13 remedial directions, 30 formal removal notices, and we've taken 1 matter to federal court. We have never had police. We have MOUs with the AFP, so federal, state, and territory police, ever refer to us an aggravated offense like this or asked us for help on image-based abuse, other than when they may have taken on a more egregious case using 474.17, just sort of, going through the process and having us commence the takedown action. So I think we did say in our, we've never had a situation where we've had, because we've used our remedial powers, I think, successfully. Anyone, repeat offend more than 3 times that we've ever been made aware of. I think it's good to have in here as a backstop. We would, of course, welcome that. We continue to refer cases that reach a criminal threshold, particularly if it's child sexual abuse material, to the AFP and others. So again, great tool to have in there. I'm not sure how much it would ultimately be used based on the patterns we have seen to date. Do you want to add anything, Alana?
I think you've really echoed it there, Julie. I think just circling back to your first point there, Senator, which was looking at, I suppose, how do we look at that from a behavioural perspective of victims? And what Julie's mentioned there is that we really focus on what a victim survivor needs in that instance, and that's often to get material removed as quickly as possible. And we know that we can do that through our informal powers, and that therefore allows us to get material taken down more quickly, which at times means that we may not need those more formal powers, which would enliven that aggravated offence.
Thanks very much. Commissioner, there's a review at the moment about the Online Safety Act, and that's due to report in October. That was brought forward by the government because of all these, issues that are arising. But you spoke about certain apps in your opening statement that have been created for the sole purpose of doing this type of conduct. How are you working with or working against, might be a better way to put it, the conduct of tech companies, particularly search engines, who are sharing and promoting apps like this? I guess in the context of criminalising this behaviour, do you think that will help pursue that work with tech companies because they will be on notice that this is criminal behaviour as well?
Yeah, again, I'm not sure how the mechanics of the criminalization will work. Will you throw executives who are based in Australia in jail, or would that be in terms of fines and penalties? Again, I think any tool we have at our disposal, I tend to think that the criminal provisions will be more effective as a deterrent and punishing perpetrators. In terms of, we've got of course the codes, and we've now registered 6 of the codes under dealing with Class 1 content, which is child sexual abuse material and pro-terrorist material and anything instructing in crime and violence. So, and the search engines are part of that. We actually do, as part of the remedial powers and the efforts that we take to kind of reduce accessibility of this kind of content for women, particularly when we're dealing with bot sites or sites that scrape data, or rogue porn sites that are set up for the purposes of humiliating women. What we will do is we will go to the websites and we will ask them to de-index certain content, so it's just harder to find. And in most cases, I'd say 5 years ago, they were very reluctant to do that. They were even reluctant to de-index access to a site called Sanctioned Suicide, which actually incited people to take their own lives by teaching them how to, where to point the gun so it hits the brainstem and that sort of thing. And we had commentary like, well, we don't decide what's right and wrong. And I said, this isn't just a hypothetical harm. We have proof that Australians have actually lost their lives. But as we have started to use our transparency powers through the basic online safety expectations, and we've shown that we are willing to fine companies for non-compliance or issue service provider notifications, often it isn't the regulation that drives the behavior of the companies, it's the reputation and revenue impacts. So there are a number of different tools. There are sticks, and there is also the carrot through safety by design and surfacing up some of the good positive things that the companies are doing to try and engineer out misuse, or embedding safety protections at the front end rather than bolting them on at the end.
Okay, thank you. I've got to hand over to the Deputy Chair. Senator Scarr, you have the call.
Thank you, Chair. Commissioner, this is horrifying. It's absolutely horrifying. I had a babe in the woods with respect to this and these sites, which you quoted in your opening statement, which I want to quote from your opening statement, how one of these sites is promoting itself. "We are the best deep nude service," end quote. And as you rightly say, what could possibly be a legitimate purpose for such an app or such a site? It's just extraordinary. I want to quote from Google's submission. Have you had a chance to read Google's submission?
I have not,
okay.
Sir, I'm so sorry.
No, that's okay. Because a few things strike me about it. So let me just read it for the Hansard. In December 2023, this is from Google's submission, we further clarified how Google handles sites with a high proportion of non-consensual explicit imagery in our spam policies and ranking systems guide. If we process a high volume of such removals involving a particular site, we use that as a signal to improve our results. For sites that receive a high volume of NCEI removals, which is non-consensual explicit imagery, we demote other content from the site in our search results, end quote. That seems to me to be a somewhat problematic statement. I would have thought that if someone is publishing, in the quote Google's own submission, a high volume of non-consensual explicit imagery, that should be a line that's crossed, and everything is done by every technology provider, web search engine, etc. Everything that can possibly be done is done to deregister, remove them, stop access to them. Do you have any response to that paragraph from Google's submission?
I mean, I think maybe they didn't draft it in a way. I think it was meant to sound positive, that when we see a prevalence of that, we try and demote them, so we make the accessibility lower. But what I will say is that for a lot of these US-based companies, they're not incentivized and will not act unless it is strictly illegal. And this is the challenge with image-based abuse. To date, is that it's what we would call legal but harmful, or lawful but awful. And so often these companies will draw a line in terms of the steps that they might ordinarily take. I noted the chair had said something about app stores, and that took me back to the first conversation I had with Apple. I think within the first month I was in the job, I had worked at Twitter, and Twitter allowed porn and still allows porn on the site. And I was shocked to find that both Facebook and Twitter were for. And I said, why for? These companies don't even allow users on it, not that they're age verifying it, but until 13. And the Apple rep said, oh, yeah, we define those as a business continuity app. I'm like, how can you categorize? Anyway, they changed it, and they moved Facebook up to 12 plus or 13, and then Twitter up to 18 plus. But we were the first regulator that existed in the world until someone kind of called them on it. They were trying to just get as many downloads as possible, because of course the app stores do get a 30% tithe or cut from every transaction that is done on any social media platform or app that is seated on their app store. So it's a very lucrative business model.
So, Commissioner, I'm reading that paragraph. I hear what you say. This is perhaps this is the problem. They actually state this as a positive, that their systems are operating in such a way as to demote other content from the site, whereas I look at it with a fresh pair of eyes in the context of the problem, and I wonder how...
Why wouldn't you cut it off altogether?
Correct. Am I looking at things too simply?
They're not incentivized to do that. They're trying to, use their browsers and their search engines to, and what they said to me around sanctioned suicide is we're not the arbiters of what's right or wrong, but if you as a regulator, say that this is illegal. They actually did change their tune after the New York Times did a long-form investigative piece around that, and they were embarrassed by their comments, and they realized how callous it looked. And I think things are changing, and they need to change because any kind of standard around harm is going to be subjective to a certain degree. But I think we've seen enough harmful content, and we've all done enough research in terms of understanding the impacts this has on human beings. Certainly these companies will start to take notice and be much more proactive in terms of the safety, health, and well-being of their users, or else governments will force them to do so.
Further in their submission, they talk about Google Play, which presumably is a way in which you can access apps. And they say, and I quote, Google Play's applicable policies prohibit apps that contain or promote non-consensual, pornographic or otherwise illegal sexual content, end quote. But presumably that doesn't go so far as to prevent someone from using the Google search engine to find another app store where they can presumably download these apps. Is that correct?
Well, they would be treating, I think, each of those services separately. So right. Google Play is their version of the App Store. What I would say, though, Senator, is that we're not really seeing very consistent enforcement of App Store policies. I'm sure if we did an own-motion investigation, we'd find plenty of apps that are hosted on Google Play and the iTunes Store that would show intimate images shared without consent. We had Apple in a couple of months ago. It's against their policies to be able to see, to host apps that have porn, and we were able to pull up porn, in the room with them there. Well, these clearly aren't working. So again, we're just ramping up our compliance efforts around search engines and app stores. That to me would be a clear violation of their app store policies. And we have seen them, again, occasionally act when either a regulator, a trusted flagger, or a news outlet points out that they have apps like Wiz that was being widely used for sexual extortion, that they will temporarily remove that app.
Just two final questions. The first is Google's submission talks about the issue in relation to victims of these deepfake images having to navigate removal requests through multiple online services and platforms. What's your experience in terms of how Google and others assist in terms of the removal of these images? Commissioner, you mentioned during your opening statement that a lot of the victims, their first priority is to get the images removed. How cooperative are they in relation to removing images?
I don't think that there are a lot of images that I can put on notice how many images were on Gmail or something else. I do have to say that when we point out that there is a violation of our laws and a potential violation of their terms of service, they are cooperative in terms of removing that damaging content. Like I said, 90% of our success rate in terms of getting this content down is through informal means. And we choose those pathways because they're much quicker, and we know the more quickly we can get the harmful content down, the more relief we're providing to the victim. And there have been cases where we've asked them to de-index or demote content to make it harder to find, and they have done so.
Yeah, I'm trying to get my head around this demote concept. Destroy seems a more appropriate verb, but anyway. My last question, just to go to your submission, and thank you for the detailed submission, and this might be a question for you, Ms Harper. I quote, "We also note the bill contains an aggravated offence that is linked to the Online Safety Act. This is where the offender has already been subject to 3 or more civil penalties orders relevant to the Online Safety Act. We support this provision. We note, however, that given e-safety is generally able to take action informally, this is likely to only be enlivened in rare and serious circumstances." End quote. So we've actually, and I don't want to take you into the area of policy, I don't want to cross the line, which the Chair appropriately drew for us all, but I'm trying to get a feel for how rare that would be in terms of perhaps, and feel free to take it on notice, how many situations has e-safety actually issued 3 or more civil penalty orders to the same individual?
And we can take that on notice. I think I could also, I suppose, bring back to the fore some of the things that our Commissioner mentioned at the start, and you've also framed in your question. The reason that is fairly rare, and we've put that in our submission, is because of the informal powers. Since the beginning of our scheme, we can note we've issued 10 formal warnings, 13 remedial directions and 30 formal removal notices, and we can put this in writing for you to help contextualise that within the number of complaints we've handled within the scheme.
Sorry to interrupt. I've got limited. How many civil penalty orders in that list?
We can come back to a little bit more about that, but probably better than me reading it out. So one of the 3 things I mentioned there, though, were 10 formal warnings, 13 remedial directions and 30 formal removal notices.
Are they all penalty orders? Yeah. Are they all civil penalty orders?
I think that they are, yes.
Okay. All right. Thank you.
Yeah, as I stated earlier, Senator, because I checked in with our investigative branch, we have never had a situation, and you know, they're quite creative remedial directions. We can compel the perpetrator to prove that they've deleted all the imagery, you know, not just from their phone, but from, say, their iCloud account. You know, we're putting them on notice that we will take, you know, federal court action and fine them up to $111,000. So we've never actually seen a situation where we've had the same perpetrator come back up more than 2 or 3, well, certainly not 3 times. So that's not. And I think the other thing that's important to remember is that some of the, and it's still a gendered crime, except when you talk about sexual extortion, but some of the girls and women who come to us, again, just want the content taken down. They don't want to go through a criminal justice pathway that requires them to hire a lawyer and bring the images back in court. And if the perpetrator is known to them, like is a former partner, they don't want to have to see them in court. So again, we try and use these remedial powers to, again, remediate the harm, to act as a deterrent to the perpetrators. But why I think it's great to have these criminal penalties for the more egregious ones is that, you know, we weren't set up as a punitive regime. We are about harms remediation. And so this is where I think the 2 systems work together. And as I said, we work very closely with law enforcement, and we refer today when we think something is reaches a criminal threshold.
Okay, thank you. Thank you, Chair.
Thank you. Senator Waters, you have the call.
Thanks very much, Ms Grant, and to your helper there. Sorry, your name's temporarily not on my screen. Ms Harper, thank you both. I've got a number of questions, and forgive me, most of which stems from my own ignorance about the scope of your existing responsibilities. So if there's something you can point me to read that will help answer some of these questions, I'll gladly do so. But I'm interested in whether you've got the existing power to just deplatform some of these ridiculous apps, the Notify apps. Is that something that you currently could do, or is that something that a different body could do, or is that something that we would need a new law to empower someone to be able to do?
Well, I've actually had this conversation with Delia Ricard, who is the reviewer of the Online Safety Act, because I know, both she and I have raised concerns about the fact that there are tracking and monitoring apps as a tool of coercive control to track former partners. I think nudification apps fit in the same category. And I mentioned that, these are very sophisticated organizations that are setting up these declothing apps. But if the primary purpose is to nudify, to create synthetic child sexual abuse material, or to harm women in this way, and we were able to use some of our technical regulation powers, I would welcome that kind of power to be we don't have a power like that today. Okay. I'd also note that there are some gaps in terms of our codes and standards. I mentioned the open source AI app provisions that we have pending before Parliament around as part of our designated internet service provisions. These will only cover children or because it's about class 1 material. And then we have a second set of codes that are pending and are with industry right now around preventing exposure to high impact content and pornography. But there's a piece missing in the middle for adults who may be, systemic powers or another code that we might be able to use to prevent these kind of nudifying apps that might be used against adults. So there is a definite gap there. And now is the time to be thinking about the kinds of powers that we might need to make us, more effective at a systemic level. When we put a submission into the Online Safety Act review, we actually think of the 4 different complaint schemes we have. The image-based abuse scheme is probably the best in class. One power that I would love would be to have an account removal power for this whole idea of repeat offenders. There are other things we're looking at around notification powers, around recidivism. So one of the biggest problems we see that companies are failing to tackle is the mass creation of fake and imposter accounts, which are largely used for any kind of social engineering scam, but particularly we're seeing it in the context of sexual extortion and potentially deep fakes. I mean, we've sent intelligence reports to some of the platforms saying, we're seeing about 10,000 of the same image used in all these fake accounts. And here are some scripts of, would you like to have a sexy chat is a pretty basic one. They could use some natural language processing to tackle, and they're just not doing it. So they're allowing these predators and organized criminal organizations to literally colonize their platforms and target people on the platform. So there are a range of things that we need to do. There are a range of tools I think we need. It will ultimately be a question for government and then Parliament which tools they want to grant us. But we can, of course, only wield the tools that we have today. And they're good. We're doing more than any other country in the world around complaint schemes. A youth-based cyberbullying scheme and an image-based abuse scheme doesn't exist anywhere else. Wow. So this is a service that we can provide to our citizens for free. And I think we had about 9,000 reports of image-based abuse, 22-23. Like I said, we had a 90% success rate in terms of getting that down. We've seen a changing of demographics. When it started in 2018, about 70% of the reports were from women and girls, so it was gendered, as I mentioned. About 21% of the reports today are from under 18s, which often makes it child sexual abuse material, and that's how I was talking about that intersection. But now we're seeing so much more. About 59% of our reports are of sexual extortion, and this is targeting young men between the ages of 16 and 24.
Oh, wow. Look, I'm conscious that I have a number of other questions, and I know the chair is going to give me this side eye any minute now. But so can I just read out my questions, please? And with whatever time we've got left, if you could respond. Otherwise, if you could please take them on notice. Thank you for that initial answer. Related question is, do you have existing powers, or does anybody, to ban the advertising of those dodgy apps? I'll call them dodgy apps, but those apps for nudifying, on either on socials or on search engines generally? Does anyone have that power? Is it you? And, what do you think about, should you have that power? I'm also interested in who does the ratings on the apps. One of the wonderful witnesses we just heard from was saying that one of those apps, not sure if it was a Notify app specifically, but it was an app that had been rated as appropriate for 4-year-olds and up. And it did not sound appropriate, in my view, for that age group to be accessing. So I'd like to know who does those ratings, and is there any, is there any leverage there that can be used? I would like to know generally what additional powers you think you need in order to be more effective at protecting people online, and obviously within the confines of this particular inquiry about deepfake abuse specifically. But I'm just interested in, having done it for quite a while now, what do you think's gone well, but what do you think you need more regulatory flexibility on? And my last question pertains to some comments that one of the earlier witnesses began the day with, about how she felt that there had not been as much input from survivors in the design of the work that you and your organisation do. And so I'm interested to hear from you about how you will incorporate that lived experience from survivors into your work style and work plan, and whether you've got any sort of formal ways already of doing that. And they were all of my questions, and I think we're at time.
Commissioner, Commissioner, I will probably encourage you to take most of those on notice and get back to the committee on it. Perhaps that last question I think might be quite important, and I think you were about to address it there.
Thank you.
I will turn over to Alana. I would. We have worked to harness the voices and the input of survivors through the creation of our National Technology Facilitated Abuse Service. I'll let Alana work through that. In terms of a survivor group for either child sexual abuse or image-based abuse, that is not something that government has tasked us with or resourced us for. I would take that responsibility very seriously, particularly when working with victim survivors who have experienced a great deal of trauma. We don't have psychiatrists and counselors on staff, and that would be something that I would want to make sure that the right scaffolding was there. But do you want to talk about our approach with the national service?
Great. Thank you, Commissioner, and thanks for the introduction. So, as the Commissioner mentioned, eSafety has been tasked with developing a new support service for technology-facilitated family, domestic and sexual violence. And that is for victim survivors of that abuse and the frontline workers who support them. And so we've been working over a number of years on that project. That includes a big period of scoping, literature review, stakeholder engagement, but I think of particular relevance for what we're speaking here was that included work directly with those with lived experience and victim survivors. There was a lived experience advisory panel as part of that group. And so what that did, that user-centred research services design gave us the framework for how we're going to develop this service. And as we move through with that service, we want to continue having lived experience inform and guide it. Now, picking up something else the Commissioner mentioned there, this is the first national service of its kind in the world, so we need to take the time to get it right. But it's not a counselling service, but nor is it a straight technology service. And what it is, it sits at the intersection of the two. And what it will do is provide trauma-informed technology support to victim survivors and frontline workers. And so now that we've got the framework for that, we're looking at how to pilot for that and then kind of test the service as we roll it out. And I think we're hoping to have an aspect of a pilot live next year. And as we do that, we're doing a lot more work. Again, with our whole of community approach, we've got more information on our website. We're working with stakeholders in this space, and a core of that is lived experience.
Thank you. That sounds positive. Maybe just check in with some of the folk who were on the panel this morning, because I think they might be really pleased to hear that that's underway, and they might even wish to be involved if it's not too late. Thanks very much, both. Thanks, Chair.
Thanks,
Chair.
Senator Waters. And Commissioner, when the Hansard's available of the hearing today, we'll make sure that you get a copy, because those advocates this morning were incredibly passionate about this issue, and there's probably some views there that I think will assist you in the work that you're doing. So we'll make sure that you get that Hansard. So thank you very much. And thank you for appearing today. That is all the time we have. I feel like we could have probably spent all day talking to you about this issue and the way that it fits into the broader work that you're doing. But we thank you for your submission and for appearing today.
Thank you.
Thank you.
Bye.
Now the committee is going to briefly suspend so we can get our next witnesses to the table. Thank you. We will resume its hearing there, and I now welcome representatives from the Attorney General's Department, the Australian Federal Police and the Commonwealth Director of Public Prosecutions. Thank you so much for being here today to take time to speak with the committee. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. Now let's see how quickly I can get through these words. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of the state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of an officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Now, for the Hansard record, can I ask you to please state your full name and the capacity in which you appear today, and we'll start with the Attorney General's Department.
Thank you, Chair. Parker Reeve, Assistant Secretary, High Tech Crime Branch, Attorney General's Department.
Thanks very much.
Nathan Whiteman, Director of the Cybercrime and Child Abuse Policy and Engagement Section at the Attorney General's Department.
Thank you. And the AFP?
Deputy Commissioner Ian McCartney of Crime of the Australian Federal Police.
Kirsty Schofield, Assistant Commissioner of Crime, Australian Federal Police.
Elijah Amparo, Acting Deputy Director of the Human Exploitation and Border Protection Practice Group of the Commonwealth Director of Public Prosecutions.
Thank you. Christina Choi, Acting Deputy Director of Legal Capability and Performance at the Office of the Commonwealth Director of Public Prosecutions.
Thank you, and no witnesses online, so that's helpful. We have a lot of questions for you today, but would anyone like to make a brief opening statement before we go to those questions? Start with that.
Well, very brief.
Wonderful, thank you.
Listen, good afternoon, committee members, and thank you for the opportunity to appear before this committee. The AFP considers the creation and sharing of sexual material representing a person without their consent to be a form of abuse. This conduct can cause long-lasting harm to victims regardless of the way in which the image was created. The proposed bill ensures the existing offences for non-consensual sharing of intimate images are modernised and strengthened to apply to both real and fake imagery generated through the use of technology. This ensures Australia's laws are capable of addressing emerging technology, including the use of artificial intelligence and deepfake technology, which can be easily attainable, affordable and simple to use. Unfortunately, deepfakes are increasingly realistic and are difficult to identify through visual inspection. We're certainly not condemning any and all use of AI technology. However, the AFP is concerned that these technologies have the potential to be used in a range of criminal offences, including fraud and scams, blackmail, terrorism, the impersonation of high office holders, child abuse and domestic abuse. It is very important that these offences remain fit for purpose in the modern technology environment, and that amendments are as robust and technology neutral as possible to ensure they remain appropriate into the future. As always, we will not canvass specific investigations in this forum, but we welcome the opportunity to discuss this crime type and the trends we are seeing. We welcome your questions today, Chair. Thank you.
Thank you very much. Mr. Reeve, does the department have an opening statement?
No, Chair.
No, thank you. Okay. I will start with questions then. First of all, if I can ask the department, have you been following along some of the witnesses we've had today? Just the evidence generally? That's good.
In general, Chair, I think the team have been able to track a little more closely than I have.
Sure. Really important question straight off the bat. What is the scope of this bill and why doesn't the bill cover the mere creation of sexually explicit deepfake without consent? I'm sure there's a drafting decision that's been made there, and if you can walk us through that, that would be very helpful.
Certainly, Chair. So, without going quite so far as providing the committee with legal advice, of course.
No, of course.
The Commonwealth does have limited constitutional powers in terms of the types of criminal offences that we can enact, and I mean that is the case across a range of different crime types, including creation of child sexual abuse material, and in this context, the creation of the creation or sharing of non-consensual sharing of intimate images. The offences for the pure creation of either adult material or child sexual abuse material are typically dealt with by the states and territories, Chair.
Okay. And in terms of the scope of this bill, what is the conduct, or what are the offences that are being created, and why are we seeking to criminalise that conduct?
Certainly, Chair. So the bill amends the criminal code to clearly set out that the criminalisation of the non-consensual sharing of sexually explicit material applies both to real material, such as unaltered images and recordings, as well as fake material or altered material that has been created or altered using technology, such as deepfakes. The amendments to the bill repeal the existing sections 474.17a and 474.17b of the Criminal Code, which currently contain aggravated offences for sharing private sexual material, and establish 3 new offences in their place. The first of those offences is for the non-consensual sharing of sexually explicit material, and then there are 2 aggravated offences which I think have been the subject of some discussion throughout the hearing this morning today. One where images or material is shared by a person who has previously been the subject of multiple civil penalty orders under the Online Safety Act, and then a second aggravated offence where the person is the creator of the sexually explicit material that they then share.
Okay. We might come back to those aggravated factors and why they were certainly chosen as the aggravating factors under the offences, but can you explain to the committee, this has come up a little bit today as well, about how the concept of consent is being imported into these offences, how it applies, what is the definition of consent that applies? Because obviously there is a shift with the new offences, not just in the way that deepfake material is being used, but even the non-consensual sharing of private material, sort of known as revenge porn. So how are we looking at this differently now in terms of consent?
No, thank you, Chair. So at present, the offences in the Criminal Code for the non-consensual sharing of private sexual material are an aggravated form of using a carriage service to menace, harass or cause offence. Yeah. So the offences are constructed around that concept of menacing, harassing or causing offence. These amendments do move to a consent-based model, focusing around whether the person who has transmitted the material knew that the person depicted in those images was not consenting or was reckless as to the fact that they weren't consenting. So it does move to a consent-based model, which really I think goes to the real gravamen of the harm of these offences, that it is the transmission or the sharing of sexually explicit material depicting the victim without their consent.
Yep. Just still on the issue then of consent and the recklessness, just wonder if you can describe what it means that the conduct can be reckless, or how someone would be reckless to consent, without asking you to give the committee legal advice. But it's come up a bit today, and I just want to make sure it's clear on the record. Thank
you, Chair. The concept of recklessness is defined in the Criminal Code, in Section 5.4 of the Criminal Code. I'll just bring that up now. So it is where a person is aware of a substantial risk that the circumstance exists or will exist, being an absence of consent, and having regard to the circumstances known to the person. It's unjustifiable for them to take that risk. Again, that the person is not consenting to the transmission of the material. The bill then also clarifies in this context that being reckless in relation to consent includes not giving into any thought at all to whether or not the person is consenting.
Thank you, that's incredibly helpful. And one last question for you before I go to the other witnesses. I probably should have asked this at the beginning, but the impetus to bring this legislation in, it's been discussed, and I'll go to the DPP soon about the submission that you made around the current laws. But can you just take us back? There was a National Cabinet on gender-based violence, and there was a commitment from National Cabinet to take forward a series of reforms, and this is part of that. Can you take us through the steps you've gone through to bringing the legislation forward to Parliament, and a time frame would be helpful? Yeah.
Certainly. So I'll start answering that question, Chair, and I might pass to Mr Whiteman if he has further detail.
Thanks.
I've come into this role since that National Cabinet decision.
Yeah.
So, Chair, in May, the National Cabinet made a commitment to address gender-based violence, and as you note, that covered a range of undertakings there. This bill is directly responsive to that commitment by government and following that National Cabinet meeting, and so has been developed and introduced as part of the delivery on that commitment. And then, Chair, as you noted, it also does address and respond to the issues raised by the Commonwealth Director of Public Prosecutions in their submission.
Yeah.
But were there more particular questions you had on the timeline? Or?
No, I just wanted to double check the timing around the National Cabinet decision, actually, because wasn't that long ago, so it's been very quick. If I can go to the DPP now, just coming to that submission that you made to the Parliamentary Joint Committee on Law Enforcement in December 2023, you mentioned the difficulties caused by the existing definition of private sexual matter. Can you describe what the problem is with the current laws and how this bill will address those problems in the way that DPP is looking at these offences?
Yes, certainly, Chair. So in terms of the way the current offence is framed, the definition of private sexual material turns on the need to prove that there was an expectation of privacy in relation to the person that's being depicted. And part of the issue that we, in looking at the legislation and applying it to matters that we've been referred, is that if you have an example of a deepfake image or an image that's been created which depicts, say, solely a person's face, but that it's been superimposed onto someone else's body, whether or not the depiction of that person's face itself, whether you have an expectation of privacy in those circumstances, and where the material is wholly fake, then our assessment was that you couldn't fulfil that definition, that there was an expectation of privacy. And that sort of formed the basis of that submission to the PJCLE. In terms of the way that the new offence is framed, it doesn't turn on that definition, as has been discussed, is that particular definition and that offence provision has been repealed and is wholly replaced, and it turns on the idea of non-consent in terms of the sharing of the material, as opposed to an expectation of privacy of the person that's being depicted.
And to the AFP, I'm going to try to share the call in a moment, but just you covered off in your opening statement some of the harms that you're seeing and the explosion of this type of material and this image-based abuse. Can you explain how you work with other law enforcement agencies across jurisdictions on this type of problem, what you're seeing out there, and what the harm... We heard from some victim survivors and advocates this morning about how harmful it is for individuals who are involved in this, but I thought you might be able to give us some evidence about what you've seen in terms of the impact on individuals who are abused in this type of way.
So, two parts to your question, Chair. Firstly, I'll talk about relationships and then pass to Assistant Commissioner Schofield in terms of impact on victims. I think the relationship, and you just before us, you had the E-Safety Commissioner on. It's just not law enforcement. It's engagement with non-government agencies and agencies like the E-Safety Commission and the work that she does. It's a very, I would say it's a very streamlined, collaborative approach in terms of addressing these issues. In terms of our relationships with the states and territories, again, in terms of the Commonwealth legislation, the previous legislation and the proposed new legislation, that's legislation that state and territory police can also use in terms of the matters that they investigate. So I think there's real merit. It's just not the AFP utilising that information. And again, it's a coordination approach for the states and territories, how we go about that approach. But I might just pass to Assistant Commissioner Schofield on the other part.
Thank you, Senator. We have, as the Deputy mentioned, we have some established joint teams. We have our jacket teams around the country. The AFP is heavily involved with those. We have working groups under the Serious and Organised Crime framework, under the SOC framework, which is Project Griffin. So we actually share information intelligence and work closely together in those environments. You asked about just some other thing too. We work jointly in cyber as well, and some of this will be dealt with in that forum. But in regards to the impact on the victims, from the AFP's perspective, the real impact we've seen is actually the use of this sort of sharing or non-consensual sharing, but it's really in the child protection space, really under 18s. Through our exposure to our state partners, we've certainly seen the trauma that this sort of material has caused victims, confidence in how they feel about what's happened to them is very real, and it has a lasting impact on them as well. So we always try and take a victim, a survivor-centric informed trauma approach to this, and we actually have victim liaison officers that we have under the national strategy, and the purpose is actually to work as a conduit between investigations and the victims, and work with other departments to help get through these sorts of things. So the AFP's real, I suppose, experience in this is more working with children, which is not really part of this legislation.
No, I appreciate that and understand it. I think we've had some good evidence and estimates as well about how that's really pulling on your resources, the proliferation of AI on child sex abuse material. I'll hand over to the Deputy Chair for questions.
Thank you, Chair, and thank you all the witnesses for appearing today. And I note from the respective submissions that you all work together in relation to this law, so congratulations on your efforts in that regard. This issue of creation, can I go to that first? I understand the constitutional law perspective. Are there any discussions in train with other state and territory jurisdictions with respect to what they may introduce as legislation to make sure that we don't have gaps in that regard, noting that Victoria appears to have very strong legislation, which I've referred to during the course of the day? What's the process nationwide in terms of addressing this issue?
Certainly. Thank you, Deputy Chair. So I'm sure as you'll be familiar, the Standing Council of Attorneys General has an ongoing and standing discussion around issues of family, domestic and sexual violence, including ongoing work under the National Strategy to end violence against women and children. In terms of discussions around this particular issue, Deputy Chair, might ask if Mr Whiteman has any further detail. Sorry, as I mentioned, I've only recently come into the role, so I haven't been party to those.
And feel free to take it on notice.
Otherwise, we'll take it on notice.
But feel free to take it on notice. From my perspective, I understand the constitutional law issue. It then begs the question as to, okay, what's happening at a national level to make sure the gap's covered, if there is a gap, in terms of other states and territories. Can you provide any further information now, or would you like to take it on notice?
Deputy Chair, I would say that we'd have to take that on notice. I'm not aware of any issues being raised recently in terms of the creation of this material. This is conduct which is generally criminalised, not the creation but the transmission of this material across the states, and so it may just be that it just hasn't necessarily been raised in a context that involves all the states and territories in the Commonwealth. But we may have to take that on notice just to double check.
Okay, if you could take that on notice. Second question's in relation to the consent issue. As I understand it, the lack of consent is part of the offence. Is that correct?
Yes, Deputy Chair, that's correct.
Okay. I've compared the consent provisions in the bill compared to the consent provisions under the Victorian law. The Victorian law embraces what we refer to as the affirmative consent model. Is there any reason, and again, I don't want to take you into policy areas where you don't feel comfortable, is there any reason why this approach has been adopted under this bill as opposed to the more particular Victorian-based approach, where is it quite explicit that unless a person does something, says or does something in a positive sense, then they have not consented, which seems to me a pretty important peg in the ground.
Yes. No, look, thank you, Deputy Chair. And I mean, you are quite correct. The definition of, or the term consent in the bill takes its ordinary meaning of free and voluntary consent rather than a concept of affirmative consent, as in the Victorian legislation or as been discussed in other jurisdictions. The Attorney-General has referred to the Australian Law Reform Commission as part of its justice response to sexual violence, sexual abuse inquiry, questions of consent and how consent should be constructed in Commonwealth law and more broadly. And I understand that is a matter which this committee, the References Committee rather, has recommended be considered by the Law Reform Commission, including in the context of state and territory experiences, having recently introduced affirmative consent laws in some of those jurisdictions. I think and part of the aspect here is that this is, of course, a targeted reform dealing with consent as a single aspect of sexual abuse, Senator, rather than a more comprehensive reform looking at how the Commonwealth Criminal Code deals with consent more broadly. So I think for those variety of reasons, including that it is under consideration by the Law Reform Commission as part of its current inquiry, and to maintain consistency across the Commonwealth Criminal Code, it adopts the standard definition of consent as it exists at present, which is free and voluntary consent.
Okay, I understand the logic. It just seems to me you've got an example on the statute book in Victoria which is quite explicit and deals with issues such as coercion, it deals with fear of force and harm, it deals with intoxication, it deals with someone being asleep or unconscious, it explicitly excludes no defence of honest and reasonable mistake. I won't press the point, but you can understand my wariness given the references committee of this committee has looked at this issue and the opportunities to change laws don't arise frequently. There is a bit of a concern that maybe it could be tighter in this respect, but I'll move on. In terms of retrospectivity, this was covered in the Bill Digest. I just want to get this right in my own mind. As I understand it, it's the position is that the retrospectivity is only with respect to the application of the aggravating feature, namely the creation of an image potentially occurring before the law coming into effect. So the transmission has to occur after the law comes into effect, but the creation could occur before the law comes into effect, and you've provided a justification as to why on that basis, to that limited extent, it's appropriate that there's retrospective application with respect to the aggravating feature. Is that correct?
Yeah, I think that is correct, Deputy Chair, in relation to how the elements of the offence apply. So the offence is not retrospective in the sense that the person must transmit the material after the offence comes into force. So their conduct must occur after the offence comes into force. The material could have been created prior to the offence coming into force. Is
that consistent with other approaches where maybe it's quite a unique position? I see our friends from the CDPP looking at each other. Never look at each other at the witness table. You'll immediately be seized upon by senators. So I'm interested to know, feel free to take it on notice, as to whether or not there are any other examples, just to give us or at least me some confidence in this respect.
Yeah, I think that there is a recent example in the Commonwealth Child Sex Offence Scheme.
Okay.
So there was the Commonwealth Possess Offence under 47422A, which came into force in about June 2020, and it turned on a similar issue in that the conduct element that was being criminalised was the possession of the child abuse material, but it was a circumstance whether or not that person had used a carriage service to access it, and that circumstance could occur prior to the offence provision coming into force. And it was a matter that was specifically dealt with by the High Court in the matters of the Hurt and Del Zotto quite recently, which confirmed that that was the case. So if that brings
well, if you're going to quote cases at me, that gives me a lot of confidence. Next one is in relation to the aggravated offences. We've had evidence from the E-Safety Commissioner, and I quote from their submission, "We also note the bill contains an aggravated offence that is linked to the Online Safety Act. This is where the offender has already been subject to 3 or more civil penalty orders. We support this provision. We note, however, that given e-safety is generally able to take action informally, this is likely to only be enlivened in rare and serious circumstances." End quote. Now, I quote that to you in the context where we've received submissions from other stakeholders who've queried whether or not the bar is too high with respect to the application of the aggravated offence component, namely the 3 or more civil penalties. What was the process that led to us coming up with the 3 or more civil penalties?
Certainly, Deputy Chair. So the 3 or more civil penalty element of that offence replicates the existing aggravated offence in existing section 474(17)A of the Criminal Code. So it is an existing part of the offences that were introduced, I believe it was in 2018.
So maybe we should change it there too. Sorry.
Certainly. So I think that was at the time when the Online Safety Act itself was being introduced, and so there was an element of attempting to set prospectively an appropriate threshold for the aggravated offence. while waiting for there to be some lived experience, some practical experience with the operation of the Online Safety Act. That Act is currently being reviewed by Delia Rickard, as the E-Safety Commissioner mentioned in her evidence. And as part of that, that would include a review of the application of the civil penalty order framework there. But in terms of how we arrived there, Deputy Chair, it replicates the existing offence.
Would the review, though, of the existing Act extend to reviewing issues like this? I suspect that would be outside the ambit of the review of the e-safety legislation, because
that is correct, Deputy Chair. Sorry, to be clear, that review will be focusing on the Online Safety Act itself, including how the various parts of that Act fit together, so the various removal notices schemes, which then transfer into the civil penalty order scheme, and how that's operated in practice.
Do you mind if I just... But Mr Reeve, we just asked the E-Safety Commissioner, does this ever happen? And she said, no, it's really unusual that you would have 3 notices that are ignored. So the likelihood of that aggravated offence being... I mean, we don't want to make the bar so low that we're criminalising behaviour when someone could just take the notice down. But we just asked the Commissioner whether it was likely. So in that context, why has the bar been set at 3 notices? Why wouldn't it be lower? And I'm just playing devil's advocate here because that's what was raised by some of the advocates. Why is the 3 notices the threshold that's been considered, other than that's just the way that it's been done before?
No, certainly, Deputy Chair. So the rationale for 3, it turns on there being a continual pattern of conduct that a person has been formally notified of, called out of, and had a civil penalty imposed on them for that. So it is that pattern of prior behaviour, which could be escalating behaviour of other forms of sort of online abuse against a person that then escalates into the transmission of sexually explicit material about that person, which then attracts the offences under this bill. And so in terms of the aggravated offence, it is where there is that demonstrated pattern of prior serious behaviour that has attracted legal consequences previously. Yeah. If a person does not meet the threshold for the aggravated offence, which has the higher penalty of under the Act, they may still be liable for the standard offence under the bill.
Sorry, Deputy Chair.
Well, no. The Chair makes a very good point. We've just heard evidence from the Safety Commissioner that it's going to be extremely unlikely that the bar is reached, and it could well be that one penalty notice, given the E-Safety Commissioner tries to resolve these things on an informal basis, is sufficient indication of aggravation. Do you see the logic from our perspective? You hear what I say?
I take the point, Chair.
Okay. I want to touch on an issue we haven't dealt with before during today, so that should get everyone's attention.
I really like when you preface a question in that way.
I do it intentionally, Chair.
I'm sure the witnesses enjoy it as well.
That's right. It's for everyone's enjoyment. I want to quote from Relations Australia in their submission, page 16, and this is in relation to an exception to the offence in paragraph 474.17 capital A1C in relation to genuine medical or scientific purpose. And this is what Relationships Australia say, and I quote, "The proposed exception is regressive in that it fails to reflect significant advances over the past 3 decades in medical jurisprudence concerning the autonomy, dignity and privacy rights of persons receiving healthcare. It is deeply surprising to find it in a bill introduced into the Australian Parliament in 2024. The proposed exception is contrary to the guidance produced by the Australian Medical Association, the Medical Indemnity Industry Association of Australia for medical students and doctors, clinical images and the use of personal mobile devices. This guidance makes very clear the significance of consent in clinical photography, as does similar guidance provided by the Royal Australian College of General Practitioners." End quote. If I can perhaps just give that to you on notice to have a look at. You might have a response now, but I'd be interested in your response in light of the guidance from the AMA, the Medical Indemnity Industry Association, with respect to what is reasonable practice in a medical context in terms of taking extraordinarily private images and using them for other purposes in a medical context, but it did on the face of it concern me, that observation. Do you have any response now?
Look, I will take that on notice. I think the one observation I would make just at this point is perhaps the distinction between a breach of the Privacy Act or professional obligations to a patient that may attract professional sanctions or civil penalties under those frameworks, and the imposition of criminal liability under the criminal code. As to whether there is a justifiable distinction between the approach we would take in those two contexts.
Yeah.
Deputy Chair,
understood.
Do you mind if I share the call and come back to you? Senator Waters has a hard stop, so I'm just going to hand the call to her, and then I'll come back to you. Thanks. Senator Waters.
Thanks very much, Chair. Appreciate that. Hello, folks. Appreciate your time in the room as well. Apologies I'm not in the room with you. I've got a vast amount of questions and I do have to go at 4, so I might just read them all out, and in whatever time there's left, if you could please start to address the ones that you can. Otherwise, I'd appreciate some responses on notice, please. The Deputy Chair asked about whether or not harmonisation of or any discussion at all about an offence for the creation of this sort of material is on the SCAG agenda, and I think your answer was that you're not aware of it. So my question is, can it please be put on the SCAG meeting agenda? I don't know whether you've got special access powers to somehow do that, but this is obviously an issue that needs addressing, and if the Commonwealth has constitutional barriers, someone's got to be doing it. To the constitutional barriers, I'd like to know whether or not the AGs have sought legal advice on whether you could use the external affairs power and our signatory status to CEDAW, the Convention on Discrimination Against Women, as a possible basis for an offence of creating this material, not the one that's proposed, creating and disseminating it, but just a creating offence. That seems to me to be within scope of jurisdiction. So I'd like to know whether or not you turned your minds to that and whether you had any legal advice saying that was a goer or not. Also interested in whether there's been consideration or might be in future of an offence about the threat to do the thing, whether it's the threat to disseminate or the threat to create the material. A few witnesses have mentioned that today. I'd also like to know whether or not the existence of this new criminal offence, should the laws pass, be included in the respectful relationships, national curricula, things that you've got to mention when you teach that subject in schools, because I'm interested in the pipeline of how people learn about this new offence. Also like to know about funding for sexual violence services under the national plan, and whether or not in particular there's enough specific things in the plan that funding for sexual violence services could be justified by to do prevention work around image-based abuse. The services say they've got the expertise to do that prevention work with perpetrators, and perhaps it's more, for repeat offenders. But whether or not you think there's enough sufficient emphasis in the plan to justify that funding decision, should government choose to allocate funds in that way. Another witness, Professor Clough, I think it was, talked about criminalising the promotion of the offence as a way of trying to get at the tech giants' responsibility for making the means of doing these offences so readily available. He's going to take on notice a bit more, give us a bit more of his thought process around that. I'd like to know whether the departments, and I guess it's the AGs in particular, have considered the scope to broaden out the effectiveness of this new offence. I'd also like to know, maybe this one's for the AFP, how do you work out whether it's a deep fake? We're hearing that it's hard to do that, but can it actually be done, and how, and who's got the nous or the ability to do that? Do they have enough funding to do it? The last question was who has the power, if anyone, to, and does it exist at the moment, to simply deplatform particular apps that can only have a nefarious purpose, like the Notify apps that have come up quite a bit in discussion today. The e-safety commissioner took that on notice, but I think said in essence she doesn't have that power already, but she would welcome it. So does anybody else have that power, and is government considering giving anybody that power? What work's being done in that regard? And likewise, can advertising of those apps be regulated? Is it regulated? Could it be? Can we ban the advertising of those sorts of dodgy apps on social media, search engines, on the internet more broadly? And lastly, who does the ratings on the age appropriateness of the apps that people can download? We heard one of the witnesses say that a particular app that had been used for image-based abuse had been initially classified as appropriate for 4 years plus. That's clearly not right. And I hope the answer isn't that the app creators themselves classify themselves, because that's clearly not working. Who does that classification, and what input can the federal government have to, to make sure that those ratings are more appropriate and promote online safety? And I think that is all the questions that I had. So, and I have to leave, so I'm sorry.
What we'll do, Senator Waters, is we'll get the witnesses to take those on notice, because there's a lot of detail there. There are some of the issues that you've raised that the Deputy Chair and I will continue to ask a couple of questions about, particularly this, the definition of transmit and how that relates to some of the issues. So hopefully we'll pick up on some of it. Otherwise, I know we'll be getting some very prompt answers from the witnesses in front of us.
Thanks very much. Thanks. Sorry for the big list of homework, everyone, and go well for the rest of the afternoon. Thanks, Chair.
That's okay. If I can pick up on that question about advertising and promotion, again, I'm not seeking legal advice. I just really would like to understand the thinking behind this definition. When you look at the offence that's being created, in offence 47417A, using a carriage service to transmit sexual material without consent, in that offence, the interpretation subsection 4 includes the definition of transmit to include make available, publish, distribute, advertise and promote. So perhaps Mr. Reeve or Ms. Abrano, am I saying that correctly? Aparo. Can you explain why that definition is crafted in that way, and what is the type of conduct that you're actually trying to criminalise? Because when I read that, it seemed to me that actually the conduct of a someone who shares not only the image but promotes that image on an online service may be captured by the offence. So over to you, Mr. Reeve.
Certainly, Deputy Chair, I might start on that.
Thank you.
And then pass to Ms. Amparo for anything else to add. So that expanded definition of transmit is intended to capture the wider range of ways in which a person may share or make available sexually explicit material about a person without consent. That is focused on, though, the transmitting, making available, publishing, distributing, and so forth, of that particular sexually explicit material that is subject to the offence in subsection 1. So certainly, to send it over a carriage service, from one phone to another, would be covered by that, as would be publishing it to a publicly available website or to a darknet forum, and then sort of advertising and promoting that material as well would all be covered. So that goes to the material itself that is subject of the offence.
Right. Do you have anything to add?
I think the only thing I'd add is it picks up on, or it uses similar wording to what's contained within the child abuse material offences in 47422, which has a particular subsection which includes transmits, makes available, publishes, distributes, advertises or promotes material. So it doesn't fall under transmits, but it's sort of all within that particular subsection.
So So I'm just trying to work out how this will work in practice. So someone might have an ex that creates a deepfake image and shares that to 10 of their friends for, awful reasons. I can see how that's covered by the definition to transmit, transmitting via phone, distribute even if it's 10 people. But if you go and publish it on a website, it might not necessarily be the person who created the content. It might be it's been shared a few times and then someone posts it, or maybe even the people who are creating these apps or these platforms or these websites are the ones that are actually publishing it. So whose conduct are we seeking to criminalise? Is it everyone in the chain, or is it particularly the person who might have created the material in the first place?
So it is. So the objective in those scenarios, Chair, is very much to criminalise the conduct of each person who transmits sexually explicit material without consent. So, the first person, and then if a second person shares it again, and so on and so forth.
Good. That is very good to know. Senator Scarr, do you have any further questions?
I do.
Yeah.
So what happens if I ask someone to share something with me? So someone has an image and I ask them to transmit it to me because I'd like to see it. Do I commit an offence under the aiding and abetting provisions of the criminal law in inducing someone to commit a criminal offence?
Yes, Deputy Chair, that would be covered either under 11.2, which is aiding and abetting the transmission of that material, or you could even be charged with incitement. And so your conduct would be covered under the extension of criminal responsibility provisions in the code.
Excellent. Good. I want to go to this issue of someone making a threat to transmit an image. So I understand the issue with respect to the creation of the image, but a threat to transmit an image, is that caught under the bill or under the criminal law?
Thank you, Deputy Chair. So, not within the bill itself. The making of a threat over a carriage service, however, could well constitute menacing, harassing, probably less causing offence under the existing 474.17. But I might turn to AFP or CPP as well if there are other offences that they might look to for the making of threats more broadly.
So maybe we'll go to the first Commissioner. Deputy Commissioner was passing it to CDPP, so I might ask him first. What would you do, Deputy Commissioner, if I ring you up?
What I always do, I always defer to my legal advice from my AG. But I was thinking more around the 4741 offence, but whether there's blackmail or extortion, I'm not too sure. Probably not if it's done for monetary purposes.
I mean, if there's that additional context, you might well look to those sorts of offences as well.
Okay. Prosecutors?
I think it would depend on the precise circumstances, I think, Deputy Chair, but...
Sure.
So there are state blackmail extortion-related offences, but under the Commonwealth Criminal Code, the best offence would be contrary to Section 474.17, which is, as my friend said, is about using a carriage service to cause harass or be menacing.
But you're not actually using it, you're threatening to use it. That's the...
Yes, it could only be captured if you're threatening either over the phone or by email, but if you were threatening in a room, that would have to be captured under some state provisions.
So rather than criminalising the type of threat, it's criminalising threatening someone in and of itself. Yeah.
Okay, thank you. One of our previous witnesses spoke about images which might be avatars, alter egos, etc. As I understand the intention around the scope of this bill, it's not intended to cover things like avatars, etc. It's seeking to cover if I can say, realistic depictions as opposed to those sorts of animated sort of depictions. Is that correct?
So yeah, the bill will apply to depictions of a real person.
Sorry,
depictions of a real person.
Of a real person?
Yes, yes.
But not if it's animated. Is that correct? Is an animation of a real person an image of a real person?
Oh, I beg your pardon. Sorry, I think we're slightly across purposes there. I was thinking of animation in the context of just a genuinely fictitious, fictional character. So the offence, the terms of the offence are that it depicts a person. There will be a spectrum, I think, of types of images that could be created depicting a person. So there's sort of hyper-realistic images at one end of the spectrum that very, very precisely, where it has been created using AI. Those images may then be modified, for example, to remove, particular features, change hair colour, and so on and so forth. The images may be of lesser or greater quality, more and more cartoonish or the like. There'll become a point where there's a question of whether that is still depicting a person. And I think that will always need to be dealt with on the facts of a particular case, Deputy Chair. Once we're getting into sort of cartoons or the like, I think we need to look at that on the facts of a particular case. I wouldn't want to attempt to draw a line beyond saying that the bill applies to depictions of a real person.
Okay, that's okay. I want to move to an issue, and this hasn't been raised before either. An issue that was raised by our professor from the US, Delfino. Have you had a chance to read Professor Delfino's submission?
Briefly, Deputy Chair.
That's okay.
If you take me to the part.
I just wanted to get a gauge as to whether or not you'd reflected on this. But the professor raises an issue around the use of the phrase other person. And just for the benefit of the Hansard record, I'll read this in. The bill states that the victim is the other person, but it does not define what the other person means, except that the other person appears to be 18 years or older. Because deepfakes are often created using digital audio images of more than one person or an actual person and AI-generated body parts, the law needs to clarify to whom the law should apply. A definition of other person should encompass all the necessary possible iterations, including multiple persons. Now, end quote. Now, clearly, on a less complicated scenario, I think it's pretty clear who the other person is, but what the professor's referring to is a situation where the image could be an amalgamation of different people. Is it the only? Is the legislation? I think this is the answer, but is the legislation only really focused on the person who's depicted? So when you first see the image, you think, oh, that is X, Y, Z, as opposed to images of someone else that are used to create that image which depicts the person. Do you understand the issue?
Head and body.
Yeah, well, head and body. Yeah, it's a good way of putting it. So
it's a crass way of putting it, but that's what you mean. Right?
So let me put it this way. You use someone's head, but you use someone else's body. Is the other person only the person whose head you're using? Does the person whose body is being used, are they considered an other person for the purposes of this section?
I think, Deputy Chair, it would probably depend on the facts of the case. I think, to take the example that the CDPP used earlier of a relatively simple deepfake where you do take one person's face and then apply it to perhaps just freely available pornographic image or video of a second person so that it depicts the first person engaging in the sexual activity from that second image or video. Certainly the objective of the law here is to criminalise for that first person to be the other person. I think if we start getting into more complex cases where we're talking about a real mashup where, potentially multiple people are being depicted in a single image, I think we would need to look at the facts of that case and as to whether you could apply it in relation to each of those other people and say they are being depicted.
Sure, happy with that answer. My last question is just in relation to children. So we've received a number of submissions from stakeholders who've raised concerns about potentially the criminalisation of these acts when they're committed by children. And I had a look at the Victorian legislation. It provides that before someone under the age of 16 is charged, it has to go to the Director of Public Prosecutions in Victoria for a direction from them as to whether or not it's appropriate for criminal penalties or charges to be brought. So my first question is, and I guess provide an opportunity for all the witnesses, including our friends from the AFP and the CDPP, how do you deal with an issue where this sort of conduct is engaged in by someone, say, who's 13 years old at high school and engages in this sort of conduct? We've heard about all these apps that are available that make it so easy for these images to be created. What's the approach that would be taken as a matter of practice generally with respect to dealing with those sorts of issues in the context of alleged offenders who are under the age of, say, 16?
Well, I think with the existing legislation, we haven't charged anybody under the age of 18. I think the key theme is discretion based on the circumstances, Senator, and in cases like that, it might be the case where it's an interdiction and prevention, and then an education from that in terms of dealing with that person. But we'd certainly have to look at it on a case-by-case basis. There's been a couple of state-based examples where children have been involved and haven't been charged based on the circumstances of the case. I think we'd really have to show discretion. Obviously focus on the victims that have been impacted, but obviously focus on the age of the potential perpetrator in that case.
Okay. Does the Commonwealth Director of Public Prosecutions have a view in relation to what policies would be triggered in terms of considering whether or not to actually prosecute a case?
So in cases that are referred to us, then we would have to look at that and assess it on in line with our prosecution policy of the Commonwealth. So as part of that policy, there are specific guidelines that apply specifically to the prosecution of juveniles. And I'd say that definitely the prosecution of juveniles is considered to be a severe step, and they're decisions that are made at a senior level within the office.
No, you're
right.
To what level does that go up to? Would that go up to the Deputy Director or...?
To the Assistant Director level, I believe it is, which is the Band 1 level.
You can take that on notice.
I'd be interested
to know how you navigate through that issue.
Can we get a copy of maybe a link to the guideline if it's available publicly? Yeah.
Given it's been raised by a number of stakeholders, it would probably give us some comfort to know what the checks and balances are.
Absolutely, and it probably depends on the offence that's being contemplated. Certainly for the more serious offending, for example, in the child exploitation, child abuse material space, that decision is actually made by the Director before we seek consent from the attorney. So it is certainly something that's taken very seriously at the CDPP.
Thank you. Thank you, Chair.
Thank you very much. That's all the questions we have for you today. Thank you for your hard work, swift efforts to bring this legislation forward. That concludes today's proceedings. This committee has agreed that answers to questions taken on notice of this hearing should be returned by close of business on the 1st of August 2024. Of course, you're always able to bring them before that date, Mr. Reeve. I thank all witnesses who have given evidence to the committee today, and I also want to thank Broadcasting and the Secretariat. I declare the hearing adjourned. Thanks, everybody.